Lordship, one affidavit has been filed today in item number 23, Lordship. An affidavit has been filed today itself, Lordship. That may be called for, Lordship. Item number 23, Lordship. Sub. The government? Yes. Item 23, Lordship. Sub. Yes. Much obliged. I think it is my turn now to deal. Okay. So, I'm little bit in a chronological order. So, Lordship has already seen the advertisement. Lordship will find at page number 109. In fact, initially prior in 2023, another advertisement was issued, but we found some flaw in that advertisement, which was not in conformity with the rules. Therefore, we cancelled the earlier advertisement, and this was a fresh advertisement issued on 2nd January 2024. Here, essential qualifications, first page, last part. Essential must have practice as a law advocate for not less than 7 years, including practice before High Court, basically on the criminal side. So what is the basic criteria? That they have to have minimum 7 years practice. Here it is not less than. You are reading the down page 109. Top it is for public prosecutor, it is 80. For others, it is 7. Yes. For others, it is 8. For additional public prosecutor, it is 7 years. And for assistant public prosecutor, it is Lordship. I agree. No quarrel on that. And also, they are basically urging that some of the candidates, they are not into practice. They went to some other fields. But what we are actually looking as for the rules, relevant rules, it is 7 or 8 years, what is the period, they must be practicing, not at a stage or on an installment. That is not the criteria. So overall practice period should be 7 or 8 years for them. And that also I told Mr. Yes, but as I am going to the qualification, it is not a disqualification. It is not a disqualification. You don't mention it in your Lordship that you have been working out there, you may be later on terminated, or you may be disqualified for whatever, maybe for not mentioning the fact. Lordship is not a disqualification to Lordship. And they were relying upon page 112, that last 8 documents to be submitted, Roman 4. And so everybody has given that evidence. They have not made an allegation that the candidates have not submitted that. That is not their case. Their case is that some of them have worked as a member of the foreigners tribunal and they have come back to practice. So that cannot be a disqualification in my humble submission. I think they have already given up that ground. In any case, page 113, I have turned down the given up, but I have. No, they are trying to now project the case in a different, which is not their pleaded case. So page 113, selection process. Also we mentioned. The selection process shall be as per the relevant provisions of Assam State Prosecution Service Rule 2023, and date, time, and venue of the selection will be intimated to the shortlisted candidates accordingly. So we'll follow the rules of 2023 regarding the selection process. In terms of this advertisement, everybody, including the 4 petitioners, they have submitted their application. And after scrutiny, all 4 were shortlisted for interview or the viva posting. And accordingly, Lordship, the admit cards were sent. Lordship will see the call letters at page 116. Top call letter for viva voce, within bracket, Lordship will, there is I am stressing upon proficiency comes skill test. For this purpose, we are doing this. One part is that their practice of 8 years. That also has given them some experience regarding the nuances of legal practice. Number 2, their educational qualification. Those things are already there. In addition to that, this viva voce has been contemplated under the service rule to see whether a good academically perfect boy, whether he will have the skill to run the prosecution or not. For that purpose, when we say viva voce, in bracket, we are stressing upon proficiency comes skill test. So this is basically a test here. For the post of additional public prosecutor, identically for all assistant public prosecutor as well as for public prosecutors. In each of the call letters, we have very specifically mentioned, while the instructions to candidate is mentioned there, the date is given 11 December, Wednesday, 1:30 p.m. Instructions to candidates. The candidates are advised to bring these call letters. All these things are there. 5 and 6 are relevant. Every candidate shall be required to produce before the selection board at least 1 copy of any application, petition, appeal, etc. drafted by the candidate himself, herself, and filed and registered before a court of law in any criminal proceeding. So they cannot draft it and just produce it. No, they have to draft a petition or an appeal or any application which has to be filed before the law, court of law in a criminal proceeding. So they cannot manufacture a particular draft of a petition and just submit it. No, that will not be suffice. So whatever they have placed before the court during the course of 8 years of practice, this application is required. Then every candidate shall be required to produce before the selection board 4 copies of any order judgment passed by a court of law in any criminal proceedings in which the candidate himself herself appeared, conducted, or argued the matter. Lordship will see appeared, conducted, and argued the matter. For 3 different categories of public prosecutors. For the public prosecutor, 6 judgments were required. For the assistant public prosecutor, additional public prosecutor, 4 copies of judgment is required. And for the assistant, it is 3 copies. Lordship will kindly see page 117. It is for the post of assistant public prosecutor, 6, serial number 6, 3 copies.
But
So
what do you say about 119?
119. This is for public prosecutor. Here it will be 6.
Did you mention from
Next page, 120. Oh, sorry.
why there are 2 copies?
No, the second page is additional public prosecutor. I'm taking their documents.
Okay, but public prosecutor, there is no mention.
They do not have any. Here there is no mention, but the instruction is also given. There is another format of giving the instructions.
That notice
That notice.
which have been included.
Yes.
It says that 17
Lordship. So this way we have proceeded with the interview.
But however, at page 122,
122.
this is for public prosecutor, you have mentioned 6 copies.
Yes, it is 6. Because the board, while devising the method of selection and the interview process, they have very categorically taken their decision. A conscious decision was taken by them. For 3 categories of public prosecutors, 3 different credentials are required. For the public prosecutor, 6 judgments. For the additional public prosecutor, 4 judgments. And for the assistant public prosecutor, it is 3 judgments.
Let us see that document.
That document I'll come down.
Because why I'm saying is this particular person at 119
Lordship.
is the petitioner number 2. Now there, you have not mentioned anything about the call letter for public
That
prosecution.
is what, this is their document, but our documents have. Yes. Yes, his lordship, very clear. They have annexed it. This was for date 9th August 2024. This interview was cancelled and the subsequent date was given on September 20. I have the date also. Next month, the interview actually had taken place.
So this is not the document on which we need to hear.
This document, in my humble submission, it was cancelled.
Because all other documents say.
Yes, Lordship will see the other documents, and other documents Lordship will find the date of interview is 11 December. Let us take the example of 116. 11 December 2024.
Because your meeting happened.
I'll come to that.
No, that
Everything
is
will
a-
get clear.
But that is a relevance out there, because if this document cannot be taken into account. It says 119. The reason for not taking account is, this is dated 9th of August.
All our interview in our subsequent affidavit, we have
No,
given the
understood.
date.
No, 9th of August.
There was no interview at all.
This
was
was
cancelled.
this admit card was prior to the decision of the selection
decisions
board
date-
on 13/8.
Decisions date I am giving you.
The decision date is 13/8.
13. It was prior to that.
So therefore, this was cancelled.
Yes. Our interview actually happened, Lordship, just for one moment. In our subsequent affidavit, we have mentioned the Viva Voce interview was held for a period of 77 number of days with effect from 7th August.
17th.
17th August, sorry. 17th August to 8th of April 2025.
Yes, Mr. Pointer, why have you entered 119 unnecessarily? We have bought another one.
Later, Lordship, yesterday.
No, but my question is, this is a document which is not of relevance.
So he also got a corrected call
Because-
letter, which I have in with
Because
me.
some,
There are 6 documents are
Should not have
indicated.
enclosed. Because this, if we only see this, otherwise this document, a court may have an impression that you were never
apart from
informed
that,
about this.
apart from issuance of the call letter, they have also uploaded in the website. Website, these grounds are clear. Because
Therefore,
yesterday
you
we
should
have
not have
produced some
enclosed
documents
this.
wherein regarding the furnishing of documents,
Okay.
So his subsequent call letter, Lordship,
Hmm.
roll number 1646, where in serial number 6, regarding 6 copies of judgment is mentioned. I'll place a photocopy of that also, little later. And he appeared in the interview on 5th of September 2024. So now let us go to that minutes of that meeting. If Lordship is pleased to take my affidavit,
Page 168.
160. Before that, I would like to also give page 166 for a moment. Who are the members of the selection group? That is also very important. Page 166, Annexure 1. The notification was issued on 20th of June, 2006, 2024. In pursuance to Rule 15 of the Assam State Prosecution Service Rule 2023, the Governor of Assam is pleased to constitute the selection board with the following composition for selection of candidates to the post of public prosecutor, additional public prosecutor, and assistant public prosecutor. 3 boards were constituted under 3 retired judges as chairperson. Board number 1, Honorable Justice so-and-so. Number 2, legal remembrancer and Secretary Judicial Department or his nominee, 1 member. Secretary Home and Political Department, a member secretary. 1 member from the NLU, National Law University and Judicial Academy. Court is 1 member nominated by the Learned Advocate General. And 5, 1 expert from the related field to be nominated by the chairman of the board. So 6 members. Second also, nominee of this number 2 is the nominee
2
of
to
the
6
senator.
remains the same.
Yes,
2 to
rest are
6.
same. So it is not that the honorable judges were only the persons who have taken the interview. These are all, and this last member, 1 member nominated by the chairman of the board, all the senior advocates, 3 senior advocates were nominated by them. Designated senior advocate. Next page, Lordship will kindly see the selection committee. Roles and responsibilities of the above selection boards are page 167, serial number 2. Evaluation of the candidates with substantial experience for the highly skilled roles like public prosecution would require a specialized testing. Lordship will kindly mark this, specialized testing for assessing the requisite qualities, drafting skill, analytical and presentation skill, mental agility, quick drafts of the arguments and quoting judicial precedents, etc. Accordingly, the selection board may devise appropriate method of proficiency cum skill test by conducting a viva voce test. Number 4, a true and faithful record of the proceedings of the selection boards authenticated by the chairman shall be maintained, which we have done. 3, decision of the majority of all the members, including the chairman, shall be the decision of the selection board, and no member of the selection board shall abstain from any decision-making meeting of the selection board. So all the members must be present. It cannot be a mechanical or routine exercise. 5, the selection board shall in discharge of their duties be guided by any general or particular direction as may be given by the government. 6, after holding the examination, this should be actually examination in a very wide term. It can be also testing of the skill. The selection board shall select the candidates in order of merit, taking into consideration reservations for SC, ST, other reserved categories. The selection board shall finally recommend the names of successful candidates to the appointing authority. Now, they had their first meeting on 13th August 2024. This meeting held 13 meeting of the members of the selection board for selection of candidates for the recruitment of the post of PP, APP, and APP. This is for finalizing methodology for conducting the proficiency test held on 13th August 2024 at Assam Administrative Office. Members present as enclosed in Annexure 1. A joint meeting of the selection board number 1, 2, and 3. This was a joint meeting, which I am trying to emphasize, has been held to work out the modalities and the procedures to be adopted by the selection board for conducting the viva voce test, for assessing the requisite qualities, drafting skill, analytical presentation skill, mental agility, quick drafts of the arguments and quoting of judicial reference, etc., for evaluation of the candidate with regard to the advertisement dated 2/1/2024 issued by the Home and Political Department of the Government of Assam for recruitment to the post of public prosecutor, additional public prosecutor, and assistant public prosecutor. They have taken note of Rule 19(2) and Clause 2 of the notification of 28 June, the notification of constitution of the board. Now coming to next page.
When come to the last line.
Yes. Having regard to the aforesaid provisions of Rule 19, Sub-Rule 2 of the Rules of 2023, as well as the Clause 2 of the notification dated 26/2024, it has to be understood that the role of the respective board would be to conduct specialized testing only by adopting the viva voce test. This is what they have come to a conclusion by reading the rules as well as the notification clause number 2. In the joint meeting, it is unanimous decision of all the members, including the chairman of the 3 selection boards, that the viva voce test would comprise of 100 marks, with 70 marks for assessing the requisite qualities, drafting skill, analytical presentation skill, mental agility, and quick drafts of the arguments and quoting judicial reference. 20 marks for assessing their requisite qualities of personality, temperament. So this is category number 2 for 20 marks, and 10 marks for overall academic performance of the candidates by taking average of all the marks up to graduation and LLB. So I have seen the marking sheets. So far as this third category is concerned, Lordship, everything is typed. Rest of the marks are on handwritten pen. That was because the scrutiny was done during in the office, and everybody has come to the conclusion that what they will get out of 10 marks, because that is a basically objective assessment. So there cannot be any change. So it was typed in the sheet. It has also been further decided that in order to aid the assessment of drafting skills, analytical presentation skills, mental agility, and quick drafts of the arguments and quoting of judicial references, etc., the respective candidates be required to produce before the selection board at least one copy of drafting of any applications, petitions, appeal, etc., done by the candidate, which has been filed and registered before a court of law in any criminal proceedings. The candidates shall also be required to produce 6 copies of judgments, orders that may be passed by a court of law in any criminal proceedings in which the candidate himself appeared, conducted and argued the matter. In respect of the post of additional public prosecutor, the number of orders or judgments required will be 4, and that of assistant public prosecutor, it will be 3, meaning that the required number of 6 will be for public prosecutors only. As is the established principles having the approval of the honorable courts, providing that if a selection is held solely on the basis of viva voce test, ideally the test ought to be 6 to 7 minutes. Accordingly, it is decided that the time to be devoted to a given candidate would be 6 to 7 minutes. That was their assessment. But finally, all the candidates were getting about 20-25 minutes, even half an hour. And for one candidate, it was more than 1 hour. So they took the decision to give at least, actually the minimum time should be mentioned. It should be 6 to 7, but
What pages are you mentioning, saying that somebody got 20-25 minutes?
yes, we have asked the office persons and also the interview board members. Let them deny. In fact, one of the read petitioner, he did not appear.
They have mentioned that paragraph number 33 of the repetition that
Sorry.
they have mentioned it at paragraph number 33, the repetition that say this thing.
Opaque. They have used the word opaque there. Opaque, no transparency. In any interview, what transparency they want? They are saying that we are not showing the categories or the marks. They are not entitled, number one. If they want to see it, they have to file an application under RTI. They will get everything. Have they applied? When there are a lot of cases, Lordships know that APSC only issues the select list, or the government issues the select. If anybody is not happy with their marks or anything, they can apply for their answer script. They can apply for their markings. Everything can be obtained. They have to do the exercise. We cannot volunteer request them that take your copy. That is not our job. If they want it, they can ask. If Lordship directs, we will produce everything. We have nothing to hide. There is absolutely no opaqueness in my humble submission. In fact, 3 boards have 3 different sets of markings. It was not given to any persons of the office. All the 3 judges said that all 3 will be present. They will sit along with all the board members, selection board members, to collate, to integrate all the markings, to find out to go to the final select list. Everything was under seal and cover, Lordship. Nothing was known to any persons in the office also. That kind of sanctity we have maintained in this selection process. The date, time, and viva voce test to be conducted shall be decided and informed from time to time. It has also been decided in the joint meeting that the viva voce for the post of public prosecutor shall be followed by viva voce of additional public prosecutor, and thereafter viva voce for the post of assistant public prosecutor. It is clarified in the joint meeting that the requirement to bring one copy of drafting and copies of judgments ordered by the candidate is not construed as an eligibility condition, but only to facilitate the evaluation of the candidates. This line is very important. These documents we are asking just to know at what level they are working and to ask all corollary questions. We have verified what type of questions were asked also. If something, some sort of arguments are coming from the other side, we'll disclose those also. What type of questions were asked? The follow-up action of the issuing call letters to the respective candidates shall take place and as done as per schedules to be decided by the respective boards. Next, further the date, time and place of viva voce would be provided in the notification to be published by Home Department and will also be appropriately placed in the website. The Home Aid Department is also required to notify that the list of candidates to be interviewed by providing dates on which the respective candidates will be subjected to viva voce test and respective call letters shall be also issued and sent to the respective emails of the candidates. It is also provided that even if in the event of a particular candidate claims that he has not received the call letter, the candidate may come and appear before the board for the viva voce test on the date as may be indicated in the notification of Home Aid Department containing the list and his candidature shall be accepted by the board, provided he can produce sufficient and appropriate document to establish his identity, which would match with the particulars provided in the application form. The meeting ended with the vote of thanks. So this modality was devised by them and it was proceeded accordingly. In the interview board, Lordship will kindly come to our additional affidavit. I would like to place 2-3 paragraphs.
Petition number 4 did not appear in
Did not appear.
This additional affidavit was served upon me at 6:30 yesterday evening. But as per my telephone instruction, he appeared.
I have the records.
Because I have received 6:30 in evening through WhatsApp.
He is not appeared in this page.
Evening project served. WhatsApp project. That's why I have only telephone instruction.
Now, if Lordship is pleased to take my additional affidavit, a rejoinder affidavit. Whatever I have placed is there. Paragraph 352, Roman A. Paragraph 5, Roman A. The deponent respectively states that the advertisement dated 2/1/2024 was issued by the Home and Political Department for recruitment of 26 number of public prosecutors, 88 number of additional public prosecutors, and 185 posts of assistant public prosecutors, totaling 299 posts under Director of Prosecution. For selection of the public prosecutor, additional public prosecutors, and assistant public prosecutors, 3 selection boards were constituted by notification dated 28 June 2024. The viva voce interview was held for a period of 77 number of days, with effect from 17/8/2024 to 8/4/2025 at Assam Administrative Staff College, Khanapara. Interview for the post of public prosecutor started from 17 August 2024 and continued till 5th September 2024. Interview for the additional public prosecutor was held from 24th September till 23rd of December 2024. And for the post of assistant public prosecutor, where the number is very high, the interview was held from 21st of January till 8th of April 2025. A total of 2390 candidates appeared for the viva voce for the 3 categories post, of which 299 candidates were recommended by the selection board. After due process, 24 candidates were appointed to the post of public prosecutor, 75 appointed for the post of additional public prosecutor, and 140 were appointed to the post of assistant public prosecutor. The details of the post, number of application received, number of candidates appeared in the interview, absent candidates, candidates recommended by the selection boards in respect of three categories are mentioned below. So far as public prosecutor, total post sanction is 34, advertise is 26, application received is 753, candidates at present 432, candidates absent 29, candidates recommended 26, candidates appointed 224, who did not join. Additional public prosecutor post is 117, advertised notified vacancy, notified advertisement was 88, application received is 1630, candidates present 771, number of candidates absent 673, recommended number is 88, joined is 75. Assistant public prosecutor 185, post sanction 185, post advertised, application received 2855, number of candidates present 1187, number of candidates absent 1367, recommended 185, joined 140. So all total, out of total application received 5232, total candidates appeared is 2390, and absentee is 2269. 299 were recommended, 239 have joined. The deponent further respectfully state that total number of 579 applications were rejected due to non-submission of draft. Overage, 4 candidates were dropped from the recommended list from the final result due to adverse report. The deponent states that the interview process continued from 17th August 2024 to 8th April 2025. And in a single day, 30 to 35 candidates were called in 2 shifts for interview assessments. Pausing here for a moment, we have 3 boards. Every day, 30 to 35 candidates were called. If all 3 boards are available, then each board will interview about 10 to 11. If suppose 2 board is available, then 22 by 10 or maybe 50, 50, 15, 16. If only single board is available, then all 30 to 35, they were interviewed by the same board, and that interview on 2 or 3 occasions continued till past 10 p.m. So everybody was given lot of sufficient time. And nobody knew which board they will appear.
How is it possible to simultaneously conduct the interview?
It is possible.
Not possible because the LR is there.
LR or his representative. Or his representative. Advocate General or his representative.
But secretary home.
Secretary, I think there are sufficient number of. The delegated can be also done. Secretary, several secretaries are here. Principal secretary is one.
Let us not go to that.
It is possible because in any department there can be multiple secretaries. Yes, Lordship. Secretary, principal secretary is one, additional principal secretary 2, 3, and there are several divisions. Home and political, law and order. In finance, there are multiple departments, more than 10 departments are there in under finance department. Secretary is a much below post, Lordship. It is not a very senior post. But when then district judges were also there. District and session judges were also there.
No, see, that's the thing. Only thing is, with regards, we had around 390 candidates who participated. This is as per your attribute.
So 2,390,
390.
Lordship,
390.
and 77 days interview.
And now total application received was 5,230.
Lordship.
There were rejection of 579.
Yes.
And total number of candidates who were present were 2390.
Lordship.
And total number of candidates who were absent were 2269.
Lordship.
Of which the petitioner number 4, who was date fixed on 27/11/2024, he did not. Let's look. I only use only one document to the fact as regards that this point which has been mentioned about 6-7 minutes.
6-7 minutes.
They must have held it on something. Because that is the only thing. But now they are saying about 7,000, it was a big number. It's
Vague.
But actually there was a present. But anyway, at the time when the election minutes were prepared on 13, nobody knew that out of 5,200 candidates, 2,269.
I'll definitely place that. I have done that judgment also. Lordship will kindly let me finish this one or two paragraphs where the facts are very important. The deponent, the 35 candidate were called from two sheets. Assessment and call letters were issued to the candidates. Individually, apart from that, due notifications was also issued in the official website of the department, notifying the details of the candidates invited to appear before the selection committee, including the instructions. The call letters and the aforesaid notification provides the details of documents materials to be brought by the candidate while appearing before the selection board. The deponent respectfully states that although meeting of the selection board has decided to allow 6 to 7 minutes of the candidates for viva voce test, during the process of interview, the candidates were given 20 to 25 minutes in the viva voce, and in respect of some candidates, even 30 to 35 minutes were also given in the interview. The selection board, after assessment, has given marks to the candidates individually, and after completion of the process, merit list of all the candidates and recommended lists were prepared after amalgamating the respective lists prepared by the three selection boards. Then Lordship will kindly see that minutes of the second. Page 364, this is important. How they have collated the marks. Resolution dated 21/6/2025 adopted in the joint meeting of the three selection boards. In terms of clause 4 and clause 7 of the rules and responsibilities of the selection board, as provided in the notification dated 6/26/2024, three selection boards had a joint meeting for preparing the merit list and the recommended list after amalgamating the respective select lists prepared by the three selection boards upon completing the interview process. The amalgamated list is the merit list under clause 6. And upon working out the number of vacancies for the three categories of public prosecutors, additional public prosecutors, and assistant public prosecutors, as well as taking into consideration the number of posts for the respective reserved categories, as provided in the advertisement dated 2nd January 2024, the recommended list have been prepared under clause 7 of the merit from the merit list under clause 4. It is to be noticed that names of some of the candidates finds place in more than one category, that is public prosecutor, additional public prosecutor, or assistant public prosecutor. In respect of such category of candidates, the recommended candidate, upon exercise of his option as to which category he desires an appointment, the resultant vacancy in other categories for which such category of candidates have also been recommended would be filled up from the remaining candidates in the merit list strictly in order of merit category and taking note of the reservation. It is resolved accordingly. So all the chairpersons and all board members were present in this meeting and they have prepared the final list. Lordship will see their signatures. Next page. Then page 367, these are the notices. Each notice contains about 30-35 candidates, some are 24. So very limited persons were called every day. Most of them, only 24 candidates were called on each day of interview. Then page 385, recommended list for the public prosecutors. These are the roll numbers and all three board members have signed. This is for the post of public prosecutor 385. 386 additional public prosecutors. Here, 88 number of candidates were recommended. All the members of the three boards were present and they collated the marks and prepared a final merit list, including reserved categories also. Then 388, it is for the recommendation for the assistant public prosecutor. Here the number is much more. It is 144.
Quite a substantial number of female candidates.
Sorry,
Quite a substantial number of female candidates in the system.
women empowerment.
Yeah. The new.
Because there are two issues here. Those who are having a very good practice, they do not want to come and join here. That is one issue. And very skillful ones also, they do not want to join. Although we are giving a very good pay package, but in spite of that, that is why out of 299, we could fill up 244 only.
No, we find it also in the recruitment for the subordinate judiciary also. There are a lot of female candidates.
Now, Lordship,
You can see the new, all the grade 3,
Lordship,
they are all mostly female. Mostly, and the new entrants are all female.
very correct, Lordship, correct assessment. And if you, when you see the results of any examination, let it be matriculation, higher secondary or other examination, the female percentage is very high. The top merit holders are also coming from the female. So there is, we cannot differentiate nowadays. So from both genders, people are coming and joining the program here also. So that is the reflection of the overall societal improvements.
Okay, we are.
Now, and they are markings, Lordship.
You see, Mr. Advocate General, I have taken note of everything. My question is only one thing you need to show. Their only case which I see is 19.2, which they are saying. Now, whether 19.2 should have been in this language or not, it is for the rule making authority or any court deciding the particular rule, that is the division bench, which I don't have the confidence. Now, there is no quarrel with the proposition that the law, that you can very well go for viva voce. There is no quarrel with
No
the proposition
difficulty.
for specialized.
Law is well set.
In fact, in that MP judgment, which yesterday Mr. Kane Chaudhary was also showing, which was referred to in Tej Prakar, there also it is said that yes, you can, but there will be a little bit, the latitude of judicial scrutiny would be much more on that. I've seen all these things. My only question is, show me that thing as regards 6 or 7 minutes or 20 minutes, whatever it may be, whether you have held 20-25 minutes is a question of fact which is there. I cannot touch again there else. But that is also very difficult. Only thing is that you need to show me that you have formulated a policy of 6-7 minutes. That is a matter of record which is apparent from that. Now, whether that is permissible only for having an interview, show me that. I think that will be enough for completion.
And their positions, Lordship will find.
I've seen it.
I'll have to
I've
Lordship.
seen it. We have
So they are down below in the merit list.
Yes, you see, that is why I put in that question. No, why petition number 4 did not appear?
And we have very made the catalyst that petition number 4 did not appear.
Page 356 and
58, that he is not appear. So then 2008. 2008. Then 1981, Forest. 1980. Lordship, 1981 4 SCC page 159. Regarding timing, Lordship, I'm coming because that Patwari's case where 400, 500 persons were called. That was in a different thing, but that was found to be a farcical exercise. A 1981 4 SCC page 159.
And as regards contemporaneous record, which are there, that is one of the arguments. Your case is out here that we have stated that these records of drafting is not just the drafting of a particular document before the selection board. It is the drafting of a document which is a matter of record before the
Court, and it was submitted, placed by them, and it was returned back because from that was the cue taken by the interview to frame their questions.
No, and my question is retaining the records.
That is not required, Lord.
Not required because that is a record which is there contemporaneously with the records of that case.
That case in the court number 1, and the judgments are all court's record either in the journals or in the court if it is a non-reported case.
So that number is.
It is. So what we have asked, give us a judgments of a criminal court. That judgment is a record. Give us a petition which is registered in a court of law in a criminal proceedings. That is also a record. So if that is required, we can place it. But those were obtained because the learned members of the selection board, they want to put questions. What type of questions? What was your strategy? If you had from the other side, what would have been your argument? All these consequential questions were asked by them. What is your strategy to fight this case as a defense lawyer or as a prosecution? To test their skill. So from strategic point of view, that cue was taken, and from that, all supplementary questions followed. And they wanted that they were not aware what will be asked. When the admit card as well as the notice very clearly said, bring your own stuff. You are the author of those documents.
Yeah, they knew that.
They knew.
In
fact, it has made them very easy to appear in the interview board.
They say that they did not know the 70% was on that, 20%.
How that will prejudice them? It has to cause prejudice to them. It will not cause prejudice to them. 10 marks for their academic qualifications, academic performances, 20 marks for their appearance and other things, and 70 marks for their skill.
In fact, if you see the judgment of State Prakash, the reference to paragraph number 51 and 52,
Lordship.
has to be considered to be a reference in the context of A. Manjushri's case
Lordship.
pertaining to recruitment. Yesterday, there was a submission made the day before. Later on, when I just went down, then I realized that the submission is wrong. You see, there is a difference between the word recruitment and selection. Selection is not recruitment. Selection is a part of the recruitment. Selection, recruitment will include first assessing what are the posts. Thereupon issuance of a notice at the time. Whereas selection is different, which is a part of the recruitment side. Here, if you see what came on this is the case wherein question was as regards the change of the rules in respect to the recruitment process. However, in 21.4, which is the second question which is being put in Tej Prakash, is whether these very principles should be applied in respect to the selection process. Then it's the Supreme Court say, the Constitution then say that no, it has to be lenient in that regard. Because the selection process, selection board will be, they have to involve its own procedure.
Yes.
In contractual terms, taking into account that I think now the bench board, fair play enjoys.
A different terrain.
With judgment You have given two judgments, huh? One is Tej Prakash and the other is that, what is the name? Give another judgment. So, that is the and there, but the issue there was why the very written marks were not taken along with the Bugabos who denied it.
They have given up the first part, the written test marks, totally relied upon the interview mark. That is not the case. That is where the factual background of that case is totally irrelevant and uncovered in our present situation. The Lordship will kindly take 1981 4 SCC, page 159 Liladhar versus State of Rajasthan. Two paragraphs I would like to place, Lordship. 1981, volume 4 SCC, page 159. Paragraph 6. Thus, the written test assesses the man's intellect and the interview tests the man's himself, and the twain shall meet for a proper selection. If both written examination and interview tests are to be essential feature of a proper selection, the question may arise as to the weight to be attached respectively to them. In case of admission to a college, for instance, where the candidate's personality is yet to develop and it is too early to identify the personal qualities for which greater importance may have to be attached in later life, greater weight has perforce to be given to the performance in the written examination. The importance to be attached to the interview test must be minimal. That was what was decided in this court in Periyapuram versus State of Tamil Nadu, Ajay Hassia and others. On the other hand, in the case of services to which recruitment has necessarily to be made from persons of mature personality, interview test may be the only way, subject to basic and essential academic and professional requirements, which we have done, 8 years practice, etc. Subject to basic and essential academic and professional requirements being satisfied. To subject such persons to written examination may yield unfruitful and negative results, apart from being it is an act of cruelty to those persons. There are, of course, many services to which recruitment is made from younger candidates whose personalities are on the threshold of development and who show signs of great promise, and the discerning may be, in an interview test, catch a glimpse of the future personality. In case of such services, where sound selection must combine academic ability with personality, promise, some weight has to be given, though not much, to create a weight to the interview test. There cannot be a rule of thumb regarding the precise weight to be given. It must vary from service to service according to the requirement of the service, the minimum qualification prescribed, the age group from which the selection is to be made, the body to which the task of holding the interview test is proposed to be entrusted.
which paragraph?
Paragraph 6. Paragraph 6 and paragraph 8. It is a matter of determination by experts. So here the experts have devised their method. So these are the things which, while preparing the rules also, these were all taken into consideration. It is a matter for research. It is not for the courts to pronounce it unless exaggerated weight has been given with proven or obvious oblique motives. The Kothari committee has also suggested that in view of the obvious importance of the subject, it may be examined in details by the research unit of the Union Public Service Commission. Coming to paragraph 8. The second ground of attack must fail for the same reason as the first ground of attack. The rules themselves do not provide for the allocation of marks under different heads at the interview test. The criteria for interview test has been laid down by the rules. It is for the interviewing board to take decisions whether to allocate marks under different heads or to award marks in a single lot. The award of marks under different heads may lead to a distorted picture of the candidate on occasions. On the other hand, the totality of the impression created by the candidate on the interviewing body may give a more accurate picture of the candidate's personality. It is for the interviewing body to choose the appropriate method of marking at the selection to each service. There cannot be any magic formula in these matters, and court cannot sit in judgment over the methods of making marking employed by interviewing bodies unless we say it is proven or obvious that the method of marking was chosen with oblique motive. So whatever we have done, Lord, only prove that their case is that they were not notified in which category how many marks will be given. That is actually not part of the rules also, and that is not required in my humble submission. This is the internal method adopted by the interviewing board, and the same level playing field is given to all the candidates. It is not that some candidates knew about the 70, 30, and 10 marking system. Nobody knew about it. It was the internal assessment. It was the internal audit decision in which category what marks will be the optimum level. And in that view of the matter, Lordship, I do not agree to the submissions made by the other sides. Now, regarding the timing, the Satpal scale.
The issue regards the fact that there was no written test.
No,
Written test. Can they
No.
raise that issue? Taking into
they
account
raised that
that
issue by challenging the rule. They have not challenged the rule here.
they challenge the rule.
Rule challenge, that is a different ball game. That is a different. Now,
It's okay.
That
I
is
can't-
okay.
But you have separately challenged. So that,
If
no,
they-
but
then
no,
they should have-
that is a
there is a
different
delay.
thing. No, that's a different thing. But can you challenge the selection? Having participated in the Vivavas,
multiple cases are there. Only if,
now
if
on
they
this
have
point,
participated in the selection and came to know about the illegalities during the course of that interview process or something, then they can challenge. Otherwise, the law is well settled. Once you have accepted the games, the rules of the games, and participated, and when you are unsuccessful, you come back and challenge it. That is not permissible. But their participation is required to know the illegalities. In that situation, there is a slight relaxation in the settled position of law. If a contra judgment, I will say, Lordship, Satpal's case, 1995 1 SCC page 206, 1995 supplementary 1, 1995 supplementary 1 SCC page 206, paragraph 6. Now, so far as the selection process is concerned, the learned counsel for the appellants invited our attention to the affidavit filed on behalf of the board in the High Court, wherein it was stated in reply to the allegations of paragraph 5 of the petition that 400 candidates were called for the interview daily at different places, and the interview commenced from 9 a.m. with a lunch break of half an hour till late hours. It was further stated that sufficient time was devoted in interviewing each and every candidate to adjust his or her ability and suitability of the said post. Some of the candidates could not even reply to a single question, and hence very little time was taken away from by such candidates. A copy of this affidavit was made available to us in the course of argument. Our attention was also drawn to a short counter affidavit filed by the secretary of the board in the present proceedings, wherein it is stated that in paragraph 4, that 400 to 600 candidates were interviewed on each day from 9 a.m. till late hours. From the said averment made on behalf of the board in the present proceedings, both before the High Court as in this court, it is clearly emergence that one single day, as many as 400 to 600 candidates were interviewed by each committee appointed by the board. Even if one were to assume that the committee devoted as many as 12 hours from 9 a.m. to 9 p.m. on a single day for interviewing candidates, it would not be able to devote more than 2 minutes time per candidate. Assuming for the sake of argument that as some of the candidates were not able to answer even a single question, the time taken by them was brief. It could not be less than a minute. And therefore, it is difficult to hold that the interviews were meaningful and purposive to enable proper assessment of the knowledge and suitability of each candidate for the post. The High Court was therefore right in commenting that the interview were a mere farce and mockery, and it was humanly impossible to effectively interview as many as 400 candidates in a single day. So our case is very simple. 3 boards, 11 up to 12 persons in each board, or maximum 30 each day. So there is no such situation that sufficient time was not given. Another case of the constable case, which went from Gauhati High Court to the Supreme Court, Sadananda Haloi. That case, Lordship will find in the judgment. 2008, Volume 4, SCC, page 619. Paragraph 35, 40, 44, 45, and 63. This is for constable. Thirty-five, Lordship will kindly come to is 636. Similarly, we are not impressed with the complaint that the district-wise restrictions was removed by the government in its later dated 6/11/2004, apart from the fact that both the courts have not commented on this aspect adversely against the selection process. We are of the opinion that itself cannot be a reason to find fault with the selection process, again on the ground that the petitioners were not able to show as to what prejudice was caused because of the removal of such step by the government on 16/11/2004. On the other hand, we are of the Sadananda Haloi. It has not been given. The multiple facts are there. There also interview time was a crucial thing that was considered. Interview, the number of day. There are 30 minutes. 35, 40. Sardar Singh's case. Para 14. However, in Sardar Singh's case, the court specifically observed the selection is for the Patwaris in class 3 service. The ratio of Vasu Kumar Yadav has no application to the facts of the case. Therein, the selection was for class 1 service of the state service, and sufficient time was required to interview each candidate. In this case, on calculation, we find that an average 3 minutes were spent on each candidate for selection. Rule 7 of the rules provides that the qualification namely pass in the matriculation, higher secondary, knowledge in Hindi, Punjabi, the middle standard, and good knowledge of rural economy and culture. The educational qualification was apparent from record and with no interview in this regard. It could be seen that the candidates normally hailing from rural backgrounds had presumably good knowledge of rural economy.
Not paragraph 50.
50. 58 and 62, Lord King.
50,
50.
58.
It is a settled law that in such a roving inquiry, that is already there. Lord. They are trying to do a roving inquiry on the basis of our affidavit. They are trying to build up their case. That is not permissible. I would have gone to that point. They started their roving inquiry after we filed the first affidavit. Now, second affidavit.
Now, you see, these
There is
judgment
no
of,
pleadings at all.
this judgment of Sadananda Haloi may not be applicable here because there
2-3
you
points
had
it is
to
applicable.
go into the question of there were more particularly there were physical tests and all these tests were there and then there was an interview. And all. So that is a
That
different
interview
aspect.
part also, here the division bench and the learned single judge committed a mistake by considering that we gave very less time to the persons during the viva voce. That was one of the major ground, which was reversed by the Honorable Supreme Court.
There it says the 3 minutes would have been sufficient taking into consideration.
That is why
that
this
there was preceded by
exactly. That is why Lordship, this interview board also in their language said, based on the various judicial pronouncements, 6-7, 6-7. But ultimately, practically, it is 15 to 20 minutes, 20 to 25 minutes, 30 minutes, like that. It depended upon the candidate. And that was 31 to 31 regarding interference of the court and judicial review of the recruitment process. 31 to 37.
is the paragraph. No?
From 31.
They are all above that. 31 and 37.
Thus, the court, while exercising the power of judicial review, cannot step into the shoes of the selection committee or assume an appellate role to examine whether the marks awarded by the selection committee in the viva voce are excessive and not corresponding to their performance in such case. The assessment and evaluation of the performance of candidates appearing before the selection committee interview board should be best left to the members of the committee in the light of the position that a court cannot sit in appeal against the decision taken pursuant to a reasonably sound selection process. The following grounds raised by the recruiter, which are based on an attack on subjective criteria employed by the selection board interview panel in assessing the suitability of candidates, namely that the candidates who had done their PG, these are not relevant. Although the recruiter had performed extremely well in the interview, the authorities had acted in an arbitrary manner while carrying out the selection process, would not hold any water. Paragraph 31, I would like to place. Before proceeding further, it is necessary to preface our judgment with a view that courts in India generally avoid interfering in selection process of public employment, recognizing the importance of maintaining the autonomy and integrity of the selection process.
I think this last paragraph of paragraph 37 is relevant.
Relevant, 31 is also relevant.
37 clearly see in the light of the position that a court cannot sit in appeal against the decision taken pursuant to a reasonably sound selection process.
Lordship.
Following ground laid by the requisitioner, which are based on attack of the subjective criteria employed by the selection board, interview panel in assessing the suitability of the candidates, so and so, so and so. While carrying out the event, the authorities have acted while carrying out the selection would not hold any water. Therefore, here you have said that 70% for this 92, 20 on personality, and 10 on something.
That is not their case. Their case is that why they were not notified that 10, 20, and 70 were not informed to. In my humble submission, that is not the mandate of the rules. That is not the mandate of any proceedings, any practice in any recruitment process. Paragraph 31 may be seen for a moment.
Even allegations of malfeasance or violation of the statutory rule only in such cases of inherent arbitration.
That is why must have it is not required under, and there is no mandate in the rules to disclose the modalities or the model or the method which the committee will devise to hold the viva voce case. That is not the mandate.
We conclude.
I think I'll just give the list of the cases which I'd like to like. I'll not consume lots.
Shall I like
Huh? Make your date seven. Make your date. Because senior counsel has informed that next Wednesday, if
why don't you have it during the summer holidays? Huh? What? Wow, you had difficulty. I would have defeated you just now.
in respect of the
This is the first time in last 5 years I have written down something. I don't write most of them because of the fact that it is not required. Only for the purpose of thinking that you will reply.
Lordship, two judgments, just paragraph reference I am giving. Model law, Lordship, 1995, volume 3 SCC.
There is one.
This same principle is followed till 2025. Series of judgment. This is the basis. In most of the cases, either followed or affirmed model law.
No, one judgment of Justice Chandrachud was there. Yeah, yeah. No, it. The model.
They have carved out the exception that participation is required to find out the illegalities. But here participation does not disclose any illegalities or arbitrariness on the part of the election board or in the process of the recruitment. Model paragraph 9. We are not relying it. 2021. We are not pressing them.
Alarm notification. Dictation of 15 marks of minimum. These also refer to a larger than. Look into the alarm. What is it?
One judgment Lordship. Salam Samarjit, that method.
There is the two judges differ. The matter has been referred to a larger bench. I don't see the head work.
Yes, yes.
I don't think we need to hold it.
Not necessarily. The importance of interview is stressed there.
On Mustafa is we are not relying.
No, we are not relying. Madanlal, paragraph 9. Paragraph 9. And Kiran Gupta, 2000, volume 7 SCC. Kiran Gupta versus State of UP, paragraph 20.
This is for without interview.
Which
Kiran Gupta,
Kiran Gupta.
without
Well,
interview.
the interview, it depends on several
without,
factors and the question of permissible percentage for an interview to decide on the facts of each case.
But anyway, good judgment after Madanlal doing.
24, 25, 16, 13, lot of cases are there. Seriously.
Which one? That is what I've been saying. Can they now raise the issue as regards there is no written test, there was no proper identification for giving marks, which they are saying yesterday argument is made. That there were 7,000 candidates, there were 37 times, 31 times the number of seats these people they have interviewed and all this is what has been. But can they raise that issue taking into account that they have already participated out there, never challenged that, and now they
Madanlal used that word. When they are not palatable with the results, they turn back and challenge it.
they said it is the case of I think therefore, if paragraphs are good for putting it in a text without taking, normally what we do, we take the law is this. Thereupon we give a finding with respect to the law. So there we, it's a different thing, but those paragraphs are otherwise good.
They wanted this honorable court to go for a ruling and all. That was their intention, and
paragraph-
Sadananda Haloi has taken care of it.
Paragraph 58. That
He-
Oh, Madananda. Madananda.
In that case, the High Court did that ruling, which Supreme Court deprecated. So that is from my submission, Lordship. The big case for dismissal. And in fact, lot of water was flowed. They have completed their 6 months training also, all the new recruits. And they are awaiting final posting. Any record, Lordship, we are not hiding anything. All the records are available. Whatever record this honorable court wants to peruse or see, we are ready with the records. But their submission is just like that. What questions were those records also they wanted? That is not given by any interview board.
You want the pendente. During the general assisted by Dean Arthur and senior government advocate have completed their arguments. I've also heard Mr. T.J. Mohanto, the learned senior counsel, assisted by Swenso, Mr. Arbouri Reddy, who appears on behalf of the private respondents. Mr. Keegan appears on behalf of the petitioner submits that Mr. Kane Chaudhary shall submit his arguments on Wednesday. Is the matter Wednesday, 4 o'clock. Put it. Put it. Absolutely no. 4:30, 15 minutes. But because I can't deliver the judgment, otherwise I would have delivered the judgment. Now, sir. But that is subject to cost, huh? For putting 119 to mislead this court. The cost and apart from that.
Should we keep the records not?
No, I don't think we will require the record. Only one big assessment for me by two of the votes for the big on the next week.
He will keep all the record, whatever not to.
Otherwise, not.
Keep your pen.
There is no stay to the tender. There is no stay to the tender. No. And you have gone ahead with the tender.
Not to finalize the tender subsequently.
Last date was of submission was on 13/1/2020. It
Yes, ma'am.
was submitted on 15/1.
Was yes, ma'am. On 15/1. Admittedly, after the
Show me the clause by the master.
at page 227, the close clause 7(4), Roman 4, 27.
7. One plus 7.
Clause 7, security deposit.
B.
I am referring to the additional affidavit, madam, filed by the petitioner, page 2 to 6, madam.
Yes. Within 15 days, 841. This is the security deposit for the.
Extension clause with that piece. 2 to 7 clause.
7, Roman.
Roman 2, madam, that is the extension clause, madam. If the petitioner fails to submit the bank guarantee, security deposit and bank guarantee, then with 1% levy of the penalty, they can submit with another extension period of 15 days, madam.
So the letter of acceptance was on 4/12.
Yes, immediately, the immediate date for the people of the guarantee. We are concerned, is 13.
Was it extended or was
No,
the first?
that was the.
That was the last one, extension,
25,
extension period.
Let us see the letter of acceptance. So this is 23/12.
23, 12, 25.
Yes.
But there is a provision that to pay late fee, it can be extended
Another 15 days.
until 15 days, and that was done. This was 13/1/26, that's the agency. We also can.
So you are depositing now the
It is mentioned
the
that page
bank guarantee with a penalty of 1.
correct. At page 134, your lordship will see, it is the admitted of 6 of 124. The last page for submitting the determined bank guarantee without any late fee is 23/12/25. The last date for submitting the determined bank guarantee with some late fee along with the fee is 13/26. So it is an admitted solution and there's no dispute about that. Right, we just,
When did it become 13/1?
we will first,
When did it become 13/1/2026?
there, now, pay late fine can be extended. And therefore, the admitted solution is that 124, it is mentioned itself. That is also there at page 4. For that.
Let us see the extension which was granted on after 2025. Where is the extension now? There are some emails referred to at page 127. Which are the emails? Let us see. Where are the emails?
Their own proposed notice that future.
Proposed notice states, but where are the emails? Complete?
Yes, madam, we have next the reminder letter in our annexure to.
One twenty-six, let me go by my.
Yes. Yes, yes.
Proposed notice is at page 126, 127. As paragraph mentioned. Right, 23/12/25 without any late fees or by 13/1/26 with 1% late fees in the road and 1%.
Come to page 320.
300,
Is the affidavit of opposition. This is the email sent on 23rd of December 2026. Kindly refer to the trailing mail when letter of acceptance is not issued. It is regard to inform you that the last date for submission of this further it has the last date for submission of the bank guarantee is 1%. So as to be technical, page 13. After the last date for six.
This is the email dated 23rd December 2025. Page 327 is the final reminder.
326.
327, the final reminder.
320.
12 January 26 and 13 January 2026.
Your office will remain open till what? What is
Okay,
your
for-
office timing?
6:30. The bank guarantee was submitted on 15 January 2026. Bank guarantee was submitted on 15 January 2026.
14 was closed.
14 was Sunday.
No, 14 was not Sunday. 14 was this, I think, Sankranti. Sunday. 13 was on, 13 was Luca, 14 was Sankranti. 15 is,
14 was closed.
the office was closed on 14.
What?
Not 50, not 50. Did you accept the bank guarantee on
No, my lord, that was deposited before the central register unit, my lord. Thereafter, it went to section, my lord, on some other day. That we have categorically mentioned at page 299.
However, guarantee amount is lying with them. That's the fact.
290?
299. The second paragraph, my lord, may I read it, my lord? Therefore, I say that the petitioner was, page 299. Therefore, I say that the petitioner was himself negligent and waited till the last date, that is 13/1/2026, to deposit the bank guarantee. The petitioner had ample time, that is 30 days, for depositing the bank guarantee in the office of the FCI respondent.
I'm not getting you. Which paragraph?
That page 299.
299 starts with paragraph. Which paragraph?
Paragraph 23, man.
Huh?
Paragraph 23.
Therefore, okay. Yeah, so here it is 298. Therefore, I say the petitioner was himself neglected and waited till the last day. Petitioner had everything. But can you say this statement when your show code notice is mentioned out there? And paragraph number 126, kindly see the third paragraph. The show code notice. You categorically say in this paragraph number page 127, last but one paragraph of there, where GB Loser Limited by the immediate so and so and claim to have deposited the 1% along with the so and so by transfer, bank transfer, dated so and so. So and so and stated that thank you for supporting us the guiding the BG process. I want to insert the so and so, so and so, so and so. The screenshot is attached to the transaction made. I will request you to update the person penalty charges. So and so, so and so. This is beyond the year on the one had submitted the physical copy of the year, dated, bank guarantee dated, bearing number, valid up to 5, whereas there is no provision in the IMAR. Beyond the extent that we could ended on the year, since when to have failed to deposit the liquidity bank guarantee before a so and when could that should be an violation of the eventual. Now you have also departed
As per the clause.
blacklisting. Blacklisting, you can't do that. You're challenging the blacklisting.
By one order, three things were there. Or acceptance was terminated. when, and guarantee has been proceeded, security deposit is been guaranteed put, and third, deposit. And also, a threat that, who will take steps to have your MSC sent.
Basically, take a quick step.
Quick to get along. I can't conceive of a aura that there is situation. I'll just point out one thing. Let me assume for a moment that on 13th, there could be begun, NTIP. What is your power? And you forfeit it, and you is possible. Is possible. I'm not admitting, but I am only saying that assume for a moment Roman 4. The event of the tenderer's failure after the communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7.1 by the due date for requisite security deposit in the form of bank guarantee under 7.1b and 7.1c, including extension period applicable to submission of PG only. His contract shall be summarily terminated. Besides, forfeiture of the earnest money, and the corporation shall proceed to appoint another contractor. That's about all. Any losses or damages arising out of and incurred by the corporation by such conduct of the contractor will be recovered in the contractor without prejudice to any other rights and liberties of the corporation under the contract and law. The contractor will also be debarred from participating in any future tenders of the corporation for a period of 2 years. After the completion of prescribed period of 2 years, the party may be allowed to participate in the future tenders of FCI provided all the recoveries and dues have been effected by the corporation and there is no dispute pending with the contractor. So assume for a moment that on 13th, I did not file the bank. Where is your power under this clause to forfeit the bank guarantee? The bank next money is going to do. But as earnest money is concerned, there is a clause that MSMEs are exempted from paying earnest money.
Or you can also make an argument. The act on the part to go ahead for forfeiting the bank guarantee is itself an admission that they have accepted the bank.
Because I was saying, they accept my money.
And if they have accepted the bank guarantee, then they have by, I think, section 55 of the Contract Act. Time was not the essence of the contract.
That clause may be read with,
Now I'll show that. Let me get it. I think we did. Bank's letter is at page 130. It's not my fault. This is the letter of it. Page 130. The Food Corporation of India. Verification regarding delay in issuance of bank. Just to inform you that the HDFC Bank had processed the request for issuance of a bank guarantee with BG number so and so for tender number so and so on behalf of our customer, the petitioner's name, in favor of food corporation of India. Due to certain technical system-related issue at the bank's level, the BG could not be processed and issued on intended date before the close of banking hours of 30th January 26. Consequently, the bank guarantee was issued on the next working day, that is 14 January 2026, in back office of HDFC Gauhati. That was a closed day, holiday, but they did it in the back.
And when did you apply to the HDFC for the bank guarantee?
On 30 itself. However, the effective date of bank guarantee is 13th January 26. The liability of bank guarantee starts from 13th January 26, and list of state BG is covered from 13th January. SFMS code 2027 of the BG also states the date 13th January 26 as well. Kindly turn to page 141 for a minute. This is that code 70.
136.
Yeah. 141. This is the below FMS code 7027.
One 141.
140. This is the FMS code that you mentioned. 7027. The date which they are mentioning is 13/01/2026. Active with page 137 and 124. Certificate issued date 13 January 26, 3:23 p.m. 124 for Lordships.
The thing, page 137 is the purchase of the, because the stamping.
Correct. Then 120.
I think, Mr. Goswami, I say it would be better. The moment they have accepted and gone for invocation, it is, they have duly accepted the document. And thereupon, can they now say that we have not accepted it? Once they have accepted it, by operation of law, they have extended the period. And once they have extended the period, time being not the essence of the contract in so far as 7 Roman 4, the further actions is bad. I think that is a better way than to go into.
I think you are ultimately very correct. That's the.
Because the moment they go, because normally if they are exercising 7-4, they should have forfeited only the earnest money.
And which.
But the moment they are forfeiting the bank guarantee, it is the security money which they are for.
And they have no power.
No.
Yet they are
So
doing it.
therefore they have accepted it.
Accept it. That's what I'm saying. Don't have the power to forfeit under clause 7(4).
My lord, let me submit.
The different thing. On 13th also it is not published. The fact that the document was there. They took steps. Yes.
On the last day, on the last day.
Taken step 3 days before. Or 5 days before, or within that. But the fact remains that your last email is that on 13th at 4:43.
Reminding him that today is the last day. Reminding the petitioner that today is the last day, 13-1.
Reminding the petitioner that you submit it today.
Yes, today only.
Then when your office gets to 4:43.
But admittedly, they have submitted on 15-1, my lord. They have admittedly, they have submitted on 15-1, my lord. 15-1-2026, my lord. I think they have, they have obtained the, I think the bank guarantee on 14, my lord. 14 or 15. 13, it was not prepared, my lord. They have taken steps only on 13, my lord. My lord, one clause 9C may also be read with the clause 7.
137 you see, kindly see the bank guarantee. Date of issue is on 14/1. Down below. 137 down below. See the date, the non-judicial stamp paper of the part of the.
Date of issue is 14 January 2026, man.
That is why 14/1.
So 31, it was not prepared, man.
13/1 it was not prepared because this is what has been given by the HDFC, that they approached us on that.
But the, my lord, the clauses,
No,
the clauses say that
no, but Mr. Counsel, you kindly see this particular document and I see. Where's your bank statement? Kindly see his bank statement, this amount was deducted of. Kindly see on 13/1/2026, page 142. The fact that it was there, it was the bank's mistake, which has happened, which is also admitted by the bank.
my lord, that has also been taken care of by the agreement, my lord. It states, specifically states that it is the responsibility of the bidder to ensure that such payment is credited to FCI account within the scheduled time. FCI will not be responsible for the delay payment of the SD due to the failure of the third party like bank, my lord.
Understood. So therefore, what is a contract, Mr. Counsel? A contract is a volition between both the parties. You have written contract. Why on earth did you go for invocation of the bank guarantee? No, forget about a similar contract. My question is why you have gone for invocation of that bank guarantee? You should have said, okay, bank guarantee, okay. We are going to only go for the earnest money. The moment you are going for the invocation of that bank guarantee, you have changed the terms of 7/4. So this changing of the terms by you, now you cannot say to that effect that look here, whatever maybe we have made a mistake to the effect that
We have invoked that bank guarantee. That may be the mistake, my lord, but that doesn't.
no, that means that you have accepted the bank guarantee.
In a similar case of the Punjab and Haryana.
Punjab and Haryana, go to Punjab and Haryana,
I'm
wherever
just-
he
I'm
goes.
just- I'm
He's
just-
here. He's here in Gauhati.
That bank guarantee was be there for taking care of the risk and cost, my lord.
Absolutely. The bank guarantee will be
when-
there for the risk and
definition.
cost. There is no quarrel with that proposition that it will be for risk and cost. The bank guarantee, there is no risk and cost for the bank guarantee. Are you making that submission, Mr. Singh? The bank guarantee is for risk and cost.
My lord, another clause may kindly be seen also, my lord, read with 9C, my lord.
What is that? Let us see 9C. 9C, when do you invoke the bank guarantee? The security deposit.
And a 9 security deposit. madam.
Ah, where? When
235.
do you invoke the bank guarantee for security?
The first clause A says that the successful tenderer shall furnish within 15 working days of the acceptance of his tender a security deposit for the due, proper and complete discharge of all their obligations under the contract. The security deposit will comprise of the total of the amounts specified in the following clause 1, 2, and 3, my lord. Then, my lord, B may be kindly be read. In the case of the failure of the tender to deposit the bank guarantee as stipulated in clause 7(1), B and C within 15 working days of the acceptance of his tender, a further extension of 15 working days can be given subject to the levy of penalty of 1% of the whole amount of the security deposit. Now, my lord, D. The general manager shall have the rights to forfeit the entire or part of the amount of the security deposit lodged by the contractors or to appropriate the security deposit or any part thereof in towards the satisfaction of any sum due to the claim for any damages, losses, charges, expenses, and costs that may be suffered or incurred by the corporation. Now, my lord, the F. In the event of the tender failure after communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7(1)(a)(b), the due date of the requisite security deposit in the form of bank guarantee under 7(1)(b) and 7(1)(c), including the extension period, his contract shall be summarily terminated for future earnest money, and the corporation shall proceed for the another appointment of another contractor. So, my lord, D is there that we can forfeit the security deposit. my lord.
Yeah, forfeit the, where, when do you forfeit? The security deposit becomes a part of the contract. The moment you are forfeiting the security deposit means you have already entered into a contract by your own conduct.
Proceeds.
Already one.
I'm sorry to say the petitioner are habitual in furnishing the bank guarantee.
So next time,
Even
next,
lately, madam, in
next
West
time,
Bengal
next
recently.
time, next time you, when you realize that, you don't go for forfeiture of the bank guarantee. You go
That
for
I have
forfeiture of the earnest money.
That I have informed on the very motion day only.
See,
Madam, in West Bengal also, they have been terminated because they have not been able to furnish the bank guarantee within time. They are,
no, you terminate, they don't give the penalty. But why do you say that you is some unique plan? That is okay. But a fact remains, whatever may be. In your so-called notice, you do not say that it was not even received by our officials. Your very so-called notice is that on 13/1/2026, the bank guarantee was not being submitted. One. Then you are not supposed to use that. It is a very poisonous paper. But the moment you are using it, you are granting an extension by your own conduct.
yes. We will happy to accept him because we got the lower rate than the petitioner.
And lower rate and
We will happy to accept him.
everything is taken, it's not even authorized by their own.
No, we have not
contract.
finalized it. We have only opened the price. Not finalized.
No, that because
Yes, second one will be terminated, but we will happy to accept the petitioner. because the
That is
petitioner rate
lower,
is there.
they're doing it.
the moment the bank guarantee comes in, when the bank guarantee is accepted and good, the termination is bad and good, then the entire contract will be as it is, which is there. So therefore, you will be bound by the terms of the earlier contract. He does not do that, is your property. The thing is that if he is not able to do it at such less contract, then he will look out. We may see Mr. BP Bora again coming with another petition.
Yes, we will be in a win-win position, I think so.
You would have that situation, copy yourself. Okay,
I will take the order. Yes. Diesel prices have come down also, by the way.
come
No, it's a different thing whether the government of India grants the benefit or not. But otherwise, everywhere it has come.
India, if you go back, there to go. Yeah, we-
Mr. uh, Singh,
Yes, ma'am.
the proposition which I said was held by a four judges bench of the Privy Council in AIR 1935 PC 79, the case of Dawson Banks. That once you accept that by way of estoppel, is a waiver. Heard Mr. P.K. Goswami, the learned senior counsel, assisted by Mr. B.P. Bora, appearing on behalf of the petitioner, Mr. Union, you. Union, no union. Did you see K. Gogoi anywhere today? K. Gogoi? None appears for the respondent number 1. Mr. B.K. Singh, the learned counsel, appears on behalf of the respondent numbers 2 to 6. And Mr. M. Smith appears on behalf of the respondent number 7. The petitioner herein, which is a company registered under the provisions of the Companies Act 2013, have assailed the order dated 23/2/2026 issued by the respondent number 3 pertaining to e-tender number RO AS-22.0011.0 bracket 11.0 bracket close oblique 21/2025 CONT Division for Road Transport contract for transportation of goods from XRH Salsapara to FSD Badarpurghat via Weybridge. The petitioners have also assailed the consequential actions of the tender note of the bid document number GEM/2026/B/73196 dated 5/3/2026 and sought for setting aside the letter dated 25/2/2026 issued by the assistant manager bracket AC and also sought for direction upon the respondent authorities to refund/return the amount of bank guarantee of rupees 70,65,000 which were invoked and encashed by the respondent authority pursuant to the letter dated 25/2/2026. The petitioner also have sought for forfeiture of the security deposit amounting to rupees 11,77,500. The brief facts which led to the filing of the instant writ petition are that on 29/8/2025, a notice inviting e-tender was issued for road transport contract for transportation of goods from X-RH Salsopra to FSD Badarpur Ghat via Weybridge having an estimated value of rupees 4 crores 83 lakhs. First, it is relevant for the purpose of the present adjudication to take note of some of the terms and conditions of the said notice inviting tender. Clause 6 of the said notice inviting tender specifically stipulated about earnest money, which was 2% value of the contract amounting to rupees 26,91,432. It is also relevant to take note of that clause 6 Roman 3 stipulated that the micro and small enterprises would be exempted from payment of the earnest money deposit. It may not be out of place at this stage to mention that the petitioner is an MSME. Clause 7 of the said tender document stipulated the condition pertaining to security deposit. some of the conditions mentioned, some of the clauses, subclauses of clause 7 being relevant are reproduced here in under. Subclause Roman 2, Roman 3, and Roman 4 Roman 2, Roman 3, Roman 4, and Roman 5 of clause 7 being relevant are reproduced here in under, page 42. Pabode. Annexure 1 to the notice inviting tender stipulates the terms and conditions governing the contracts for transport, unloading, loading, handling of food grains, etc. at food corporation depots, godowns, railheads. Clause Roman 9 stipulates about the security deposit. Subclause A of clause 9 categorically stipulates that the successful tenderer shall furnish within 15 working days of the acceptance of his tender a security deposit for due, proper, and complete discharge of all their obligations under the contract. What the security deposit would comprise of have been mentioned in subclauses Roman 1, Roman 2, and Roman 3 of clause A. In clauses Roman 1, Roman 2, and Roman 3 of clauses Roman 1, Roman 2, and Roman 3 of clause Roman 9A small a. Clauses Roman 9B, Roman 9C, Roman 9D, Roman 9E, and Roman 9F being relevant are reproduced here in under. For the purpose of the present dispute, the aforementioned clauses for the purpose of the instant dispute, this court need not traverse upon the other clauses of the notice inviting tender. The petitioner herein, who was interested in submission of the bid, who was interested in the said tender process, submitted the bid. On 4/12/2025, the letter of acceptance was issued in favor of the petitioner for road transport contract XRA Solsapara to FSD Bodorpur Ghat via Weybridge on regular basis for a period of 2 years. By the said letter of acceptance, the petitioner was advised to furnish the security deposit which comprised of a sum equivalent to 5% of the estimated value of the contract, totaling to rupees 23,55,000, and a sum equivalent to 15% of the estimated value of the contract amounting to rupees 70,65,000 in the form of irrevocable and unconditional bank guarantee. It was further mentioned that the said bank guarantee, security deposit, along with the bank guarantee, should be furnished within 15 working days, that is on or before 23/12/2025, from the issue of the letter of acceptance. In the said letter of acceptance, it was also mentioned that the last date for submitting the determined bank guarantee without any late fee was 23/12/2025, and the last date for submitting the determined bank guarantee with 1% late fee along with applicable GST was on 13/1/2026. Clauses 1, 2, 6, and 7 of the letter of acceptance dated 4/12/2025 being relevant are reproduced hereunder. Page 123 and 124. The facts as would appear from the materials on record clearly show that a petitioner did not submit the bank guarantee, the security deposit, within 23/12/2025.
No, there is no dispute about the first bill, security deposit of 11 lakh, we paid within time. There is no problem about
that.
No, and it is only the bank guarantee.
There is no dis-
And page 143.
there is no
it
dispute.
mentions.
And the materials and records show that insofar as the compliance mentioned sought for at clause 1 Roman 1 of the letter of acceptance dated 4/12/2025, the petitioner duly complied with the same. However, the petitioner admittedly did not submit the security deposit by way of a bank guarantee, which is the requirement in terms with clause 1 Roman 2 of the letter of acceptance on or before 23/12/2025.
Next month it was extended to 13 months.
And that time, the records further reveal that as the petitioner did not submit the bank guarantee within 23/12/2025, of the amount of rupees 70 lakhs 65,000, various emails were issued to the petitioner on 26/12/2025, 5/1/2026, 7/1/2026, 9/1/2026, 12/1/2026, and on 13/1/2026. The email dated 13/1/2026, it is relevant to observe that the email dated 13/1/2026 was issued at 4:33 p.m. The materials on record further shows that the petitioner duly took steps before with the respondent number, your respondent 7, nah? With the respondent number 7 for the issuance of the bank guarantee on 13/1/2026. This aspect is apparent from page 142 of annexure of the writ petition, which is a part of annexure E to the writ petition. The respondent number 7, though deducted the amount for the purpose of issuance of the bank guarantee, but on account of certain technical oblique system related issue, at the bank's end, at the respondent number 7's end, the bank guarantee could not be processed and issued on 13/1/2026. However, on 14/1/2026, the bank guarantee was issued which was submitted by the petitioner on 15/1/2026. It may not be out of place at this stage to mention that on 14/1/2026, that 14/1/2026 was a holiday in the office of the respondent numbers 2 to 6.
But it has been mentioned that
Page
page 136, your lordships will see. On 14/1 that was given and they accepted in the back office. That is what they say.
Huh?
136, if your lordship see.
What? What is this?
Bank, that back office police.
There's no quarrel with this.
No,
The
no,
bank
no
guarantee
quarrel, no,
was
no,
issued.
no.
It's okay.
14th. And letter 130.
The respondent authorities, more particularly the respondent number
On 14, page 130, bank's letter state.
5, upon receipt of the said bank guarantee, issued the communication dated 25/2/2026. Which one? Where is 25/2? Page?
187. What I invoking?
To the thereby invoking the bank guarantee which was submitted by the petitioner dated 14/1/2026 amounting to rupees 70,65,000. Pursuant thereto, on 3/2/2026, a show cause notice was issued to the petitioner to explain the reasons for non-submission of the bank guarantee within the stipulated time, that is by 13/1/2026, and why action should not be taken against the petitioner as per clause 6 bracket 1 comma Roman 1, clause 7 bracket Roman 4, clause 13, clause 14 bracket Roman 6 capital Roman 6, clause Roman 9 bracket F, clause Roman 11 bracket B and clause Roman 11 bracket C and the tender submission undertaking, thereby to summarily terminate and debar the petitioner from participating in any tender inquiry with FCI for a period of 2 years and get the work done for the unexpired period of the contract at the risk and cost of the petitioner. The petitioner thereupon submitted a reply on 5/2/2026 stating inter alia that the bank guarantee in question inter alia that though the petitioner took steps for arranging the bank guarantee and submitting the same with the respondent authorities on 13/1/2026, but on account of the fault of the respondent number 7 bank, the bank guarantee could not be processed. It was also mentioned that the bank guarantee, which was dated 14/1/2026, was duly submitted on 15/1/2026, and it did not result in any financial loss, risk, or prejudice to the corporation. It was further mentioned that there was no willful default or any breach on the part of the petitioner. The bank guarantee which was submitted was valid, enforceable, and effective from the stipulated date. And further, the proposed actions of forfeiture, debarment, termination, and risk and cost execution were disproportionate and unwarranted. The respondents thereupon passed an order. The respondent who passed the order, respondent number 3, na? General Manager, respondent number 3 thereupon passed the order on 23/2/2026. Whereby the contract with the petitioner was terminated, semicolon. The petitioner was debarred from participating in any other tender inquiry with the FCI for a period of 2 years from the date of issue of the said order, semicolon. Forfeiture of the deposited security deposit of rupees 11,77,500 and the bank guarantee amounting to rupees 70,65,000 and further that the respondent corporation would proceed for appointment of another contractor for the same contract work on regular basis for a period of 2 years at the risk and cost of the petitioner. In pursuance to the said order dated 23/2/2026, as stated above, the bank guarantee was invoked by the respondent number 3 by a communication dated 25/2/2026. Additionally, on 5/3/2026, a fresh notice inviting tender was issued for the same work. It is under such circumstances the petitioner has approached this court by filing the present petition. The record reveals that by an order dated 18/3/2026, the learned coordinate bench of this court, while issuing notice, passed interim directions to the effect that the respondent FCI authorities may proceed with the said tender process initiated by the NIT dated 5/3/2026. But the said tender process shall not be finalized without the leave of the court. It was also directed that the amount that the respondent FCI authorities who have received the amount upon invoking the bank guarantee shall keep the said amount in an interest-bearing instrument until further orders. The records further revealed that the petitioner had filed an additional affidavit on 18th of March 2026 itself, wherein the model tender form pertaining to the e-tender number ROAS-22.0011.0 bracket close oblique 21 oblique CONT dash CONT oblique 21 oblique 2025 dash CONT division for road transport contract for transportation of goods from XRA Salpara to FSD Badarpur via Weybridge was brought on record. In addition to that, this court have also taken note of the affidavit in opposition which was filed by the respondents on 24/2026. A perusal of the said affidavit reveals that the petitioner has an alternative and efficacious remedy in approaching the grievance redressal committee for redressing his grievances, rather than approaching this court by invoking jurisdiction under Article 2 to 6 of the Constitution. In addition to that, it is also mentioned, in addition to that, the respondents have reiterated the factual aspect which have been mentioned, have reiterated the factual aspect which have been already dealt here in above. The respondents have also justified their action, and more particularly the order dated 23/2/2026, as well as the invocation of the bank guarantee dated 25/2/2026. In addition to that, the respondents also justified their authority and power in terms with the contract agreement to go for a fresh tender in respect to the same work at the risk and cost of the petitioner. The respondents have also enclosed the various reminders which have been issued to the petitioner as Annexure 2 series and contended in the affidavit in opposition that the petitioner was granted various opportunities and reminders, and in spite of that, the petitioner did not submit the bank guarantee of the amount of rupees 70,65,000 within the period stipulated in the contract. This court also takes note of that a reply has been filed by the petitioner on 29/5/2026, wherein the petitioner, apart from reiterating and reaffirming the statements made in the writ petition, further denied the allegations which have been made in the affidavit in opposition. In the backdrop of the above pleadings, let this court now take note of the submissions made by the learned counsels appearing on behalf of the parties. Mr. P.K. Goswami, the learned senior counsel appearing on behalf of the petitioner, submitted that a perusal of the materials on record would clearly show that it was beyond the control of the petitioner. No, it was for circumstances beyond the control of the petitioner that the petitioner had to submit the bank guarantee on 15/1/2026, referring to the various communications issued by various banks, referring to the bank statement, the bank guarantee, as well as the communication which have been issued by the respondent number 7 on 3/2/2026. The learned senior counsel submitted that the respondent number 7 have duly admitted that it was on account of a technical glitch that the bank guarantee could not be issued to the petitioner by the end of on 13/1/2026. The learned counsel further submitted that the representative of the petitioner waited at the respondent number 7's bank till 7 p.m. as would be seen from the reply so submitted to the show cause notice. The non-consideration of the aforesaid aspect by the respondent authorities, more particularly the respondent number 3, makes the action on the part of the respondent number 3 unreasonable and irrational. The learned senior counsel further, referring to the clauses number 7, referring to clause number 6, submits that the said clause categorically stipulates as to what constitutes an earnest money. Taking into account that the petitioner is an MSME, the petitioner was exempted from payment of any earnest money. First, the learned counsel further, referring to clause number 7, as well as clause number 7 of the tender of the notice inviting tender, and clause number Roman 9 of the Annexure 1 to the notice inviting tender, submitted that the respondent authorities did not have the authority and jurisdiction to invoke the bank guarantee, inasmuch as if there was a failure to submit within the prescribed period, comma. The respondent authorities in terms with clause 7 Roman 4 as well as clause of the tender document of the bid document and clause nine Roman F Roman 9F of annexure 1 to the bid document could have at best terminated the contract and forfeited the earnest money. Full stop. However, in the instant case, the respondent authorities have accepted the security deposit and if the security deposit was duly accepted, there is an implied waiver on the part of the respondent authorities to clause Roman 7 Roman 4 as well as clause of the tender document of the bid document and clause Roman 9 F of the annexure 1 to the bid document. Upon such waiver, the learned senior counsel further elaborated. To these two clauses, the respondent authorities could not have issued the show cause notice or taken the consequential actions which have been taken, which is the subject matter impugned in the instant proceedings. Per contra, Mr. B.K. Singh, the learned counsel appearing on behalf of the respondent number 2 to 6 submitted that the tender conditions was clear and specific, wherein, in addition to that, the respondents have also clearly mentioned in the letter of acceptance dated 4/12/2025 that the petitioner was required to submit the bank guarantee on or before 23/12/2025. And if it was not submitted, the said bank guarantee along with an additional 1% and with GST should be submitted on or before 13/1/2026. The learned counsel further submitted that in spite of various reminders which have been issued, as would be apparent from an affidavit so filed by the respondent, the petitioner having not submitted, the respondent authorities were justified in taking actions which have been impugned in the instant proceedings. First, this court heard the learned counsels appearing on behalf of the parties and have perused the materials on record. In the previous segments of the instant judgment, this court have quoted the clause clause 7 of the bid document, some of the subclauses of clause 7 of the bid document, as well as some of the subclauses of clause 9, Roman 9 of annexure 1 to the bid document. Clause 7, Roman 4 is parameteria with clause 9F of annexure 1 to the bid document. From a perusal of the sections of clause 7 of the bid document and clause Roman 9 of the annexure 1 to the bid document, it is clear that within 15 days from the date of issuance of the letter of acceptance, the security deposit in terms with clause 7 Roman 1 was required to be submitted. There is no quarrel with the proposal to with the fact that in respect to clause 7 1A oblique clause Roman 9 A1, the petitioner had submitted the said amount forming a part of the security deposit on 23/12/2025. This aspect is duly admitted in the show cause notice itself. However, insofar as the remaining part of the security deposit, which is to the tune of rupees 70,65,000, which was required to be submitted by way of a bank guarantee, the petitioner admittedly did not submit on 23/12/2025 or on 13/1/2026, which was the extended period. Be that as it may, it is apparent that the petitioner duly took steps on 13/1/2026 before the respondent number 7 for the purpose of processing of the bank guarantee. And the respondent number 7 thereupon, on account of, however, the respondent number 7, on account of a technical glitch, could not process the said bank guarantee and issued the bank guarantee on 14/1/2026, dating it back to 13/1/2026. It is then also an admitted fact that the petitioner had submitted the physical copy of the bank guarantee on 15/1/2026. The respondents in their affidavit, though, have mentioned that the said bank guarantee was received by the central register unit and not by the respondents number 2 to 6. But the fact remains that the respondents have duly acknowledged the receipt of the same bank guarantee in the show cause notice dated 3/2/2026. Not only that, the respondents have also it is also very pertinent to mention that a power which is reserved upon, which is conferred upon the respondents in terms with clause 7 Roman 4 of the bid document or clause 9 Roman 9F of the annexure 1 to the bid document is a power to terminate the contract and forfeit the earnest money However, a perusal of the impugned order dated 23/2/2026 though at one hand stipulates that the petitioner had violated clause 7 Roman 2 and clause Roman 2. But on the other hand, in the same order, the respondents, number 3, had accepted the security deposit, thereby directing invocation of the said bank guarantee and forfeiting, and thereby directing, on one hand, forfeiting the amount so paid in terms with amount which have been paid already in terms with clause 7 1 Roman A and invoking the bank guarantee so submitted in terms with clause 7 1 Roman B 7 Roman 1B. The fact that the petition respondents have taken steps for forfeiting and invoking the bank, in forfeiting the security deposit, part of the security deposit, and invoking the bank guarantee, which is the other part of the security deposit, it cannot be said that the respondents have acted in terms with clause 7 Roman 4 of the bid document or clause Roman 9F of the annexure 1 to the bid document. On this account alone, the order dated 23/2/2026 cannot be sustained. Number 2. This court also finds it very pertinent to take note of that a perusal of the tender conditions would clearly show that the security deposit is for due performance of the obligations under the contract. The security deposit is taken by the respondents for due performance of the obligations under the contract. In other words, the contract had come into existence upon acceptance of the security deposit. And if clause 7 Roman 4 or clause 9F cannot be invoked the only action which can be taken is in terms with clause Roman 11 of Annexure 1 to the bid document. Under such circumstances, it is therefore the opinion of this court that the termination of the contract in terms with clause 7 Roman 4 of the bid document oblique clause 9 Roman 5 Roman 9 5 of the so and so document annexure 1 would not have been invoked, for which the termination has to be set aside and quashed. The natural corollary of the said observations would be that all consequential actions taken on the basis of clause 7 Roman 4 as well as of the bid document oblique clause 9F of the Roman 9F of the annexure 1 to the bid document has also to be interfered with. This court also finds it very relevant to take note of another aspect as regards the question of debarment, which steps debarment, which is the subject matter of debarment, which have been on the question of debarment of the petitioner as per the order dated 23/2/2026. In the case of Blue Dreamers Private Limited versus so and so reported in so and so, the Supreme Court in clear and categorical terms have mentioned that in respect to cases falling within the ambit of ordinary breach of contract or when there is a bona fide dispute, resort to blacklisting oblique debarment is not permissible. It is also seen that subsequently, in another case, the Supreme Court, in the case of Technoprints versus so and so, reported in so and so, observed that in a case which is falling within the ambit of ordinary breach of contract, even issuance of a show cause notice is not permissible. In the instant case, it is the opinion of this court that the delay in submission of the bank guarantee, that too when it is not the fault of the petitioner, by 1 day would not come within the ambit of a fundamental breach of contract. Rather, it would be a case of ordinary breach of contract. under such circumstances, it is the further opinion of this court that the debarment notice which have been issued, the debarment of the petitioner for a period of 2 years cannot be sustained in law. In that view of the matter, the instant petition stands disposed of with the following observations and directions. First, the impugned order dated 23/2/2026 passed by the respondent number 3 is set aside and quashed. First, this court first, this court further first, for the sake of clarity, this court therefore further observes and directs that the termination of the contract of the petitioner in respect to Hay contract 2, dated so and so, is set aside and quashed, and the letter of acceptance dated 4/12/2025 it stands revived. Number 2. The action on the part of the respondent number 3, respondent number 4, to invoke the bank guarantee by the communication dated 25/2/2026 cannot be sustained in view of the communication dated, in view of setting aside the impugned order dated 23/2/2026. However, as the communication dated 25/2/2026 have already been acted upon, and the amount of rupees 70,65,000 has already been transferred to the FCI, the FCI shall either return the amount to the respondent number 7 or to the petitioner, to the respondent number 7. You return it to the respondent number 7, subject to the petitioner submitting shall return the year within how much days? 7 days? Within 7 days. Within 7 days. And the petitioner shall within 7 days from such return furnish a bank guarantee of the amount of fresh bank guarantee of an amount of rupees 70,65,000 to the respondent. That number 2, the debarment of the petitioner by the impugned order dated 23/2/2026 cannot be sustained for the reasons aforesaid, for which the same is set aside and quashed. As the contract in question have been revived, as the letter of acceptance dated 4/12/2025 is revived by setting aside the order dated 23/2/2025, 26. The impugned notice inviting tender dated 5/3/2026 cannot also survive, for which the said notice inviting tender dated so and so is set aside and quashed. There shall be no order as to cost.
One thing, your lordship has covered everything. That security deposit of 11 lakhs.
Ah.
That should also, They
No,
restored-
that you have already given.
You have,
Ah,
given
that's
it. They have accepted and.
আৰু এটা লিখি দিব সেই ABCD যিখিনি
Ah.
কৰিছে এটাত লিখি দিব the security deposit of rupees so and so সেইটো 11 lakh something area
11 lakhs,
so and so
50.
which was forfeited by the impugn order dated 23/2/2026 shall is interfered with is interfered with the forfeiture of the amount of rupees so and so, which is the part of the security deposit by the impugn order dated so and so, is interfered with, and it shall revert back to the respondent number 3, to the respondent number 2 to 6, as a part of the security deposit so submitted by the petitioner in pursuance to the letter of acceptance dated 4/12/2025.
Yes.
And that we will return within 7 days, within 7 days from the
Ah. He
certified.
will submit a
supplying-
fresh bank guarantee.
Yes.
And if he does not take action, we'll say that it will be deemed to be it will, if you don't submit within 7 days, they can take action, resort to action under 7(4).
But, they will submit
Within 7 days, they will refund it to the HDFC bank.
yes, and then we'll file a fresh bank guarantee within 7 days.
I give you a time. You see, this
Yes.
time will take for me to correct.
Yes,
Correct.
ma'am.
Give you 10 days, huh?
From the date of supplying the certified copy.
Ah,
That will be.
That will be
no.
better. Within 7 days from there, and then you submit. In the meantime, you get another fresh bank guarantee. You're only paying 10 lakhs or 12 lakhs.
No, 70 lakhs. Oh.
You are paying 12 lakhs for that bank guarantee of 70 lakhs. Get a bank guarantee and give
If
it
they
without
can,
a year.
they should.
That you can 12 lakhs. You'll get back the money they do want. You know about.
So, my lord, from the date of furnishing the certified copy.
Oh, 17. Because otherwise it will be difficult.
Yes.
Because this will take some time.
Time.
Correction will
Yes,
be there.
ma'am. Your lordship.
You won't get it before Monday.
No, your lordship will have to take a little time.
Yes.
We understand. No, I am only asking that they will return within 7 days
Ah.
to the bank. And we will,
From that, within 7 days thereafter, you have to submit that.
press it.
But fresh bank guarantee.
That is all.
And therefore, the only thing is here is, but if you can't delay it also, no?
No, we'll, within 7 days of their
Because
filing.
if you don't delay, his work is also being affected.
Yes, my
Yes,
lord,
yes.
because
So immediately you do.
It's
So
not
that
to our
is only
interest
a worry.
also.
it is only the worry. If
No,
it
I
doesn't-
do one
if-
thing.
If they.
No,
let
no.
them-
Within 7 days from the date, the registry of this court serves you a copy.
Yes, that is all.
Another thing, suppose they doesn't furnish the
7(4).
bank guarantee,
7(4).
then on the entire effort, my lord, there's 3 months for appointing another tender, my lord, another contractor will go. in
No.
vain.
If they don't
Suppose-
do it, then obviously 7(4) you initiate, but don't forfeit them. Only the earnest money is not there, then you take up whatever you use, because they are normal contractors. So you can
Yes.
very well go for risk and cost, because you have this clause is there, na 9E. 9E is the most pertinent clause, that in respect to other contracts, you can take that money.
Only, suppose it doesn't furnish, the only.
No,
thing is
no,
that we
we'll-
will-
Who
we
won't
lost-
furnish?
No,
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 they
My
don't
lord,
furnish.
They have not
No,
furnished
no.
in the West Bengal also.
no,
If-
don't talk about.
If they
West
don't
Bengal.
furnish, you know the
Because
consequence.
recent
No,
days-
I'm therefore saying, na, I will make it clear, na, if they don't furnish within that 7 days
Huh,
from the date you are returned,
huh.
then
And we
if
must
you
know
don't
that-
furnish it, then in the meantime, or should I do one thing?
Yeah.
You,
Furnish.
within 7 days or within 10, I give you 10 days, furnish a fresh bank guarantee. Fresh bank guarantee within 10 days.
Thereafter, we will furnish, we will return.
And directing you within 7 days from the date a copy is served to return it to the bank. It's only a 10 lakh, Mr. I think better off. That is will be less of confusion.
Overtime on my lord,
I was
let them
thinking-
furnish first, then we will return it within 3 days, my lord.
No, because you could not have invoked it.
They have invoked it and now.
No, let him.
Let them invoke within 7 days and are returned within 7 days to the bank, HDFC Bank.
Mr. Goswami, is your client interested in doing the work or not? If he is interested, then give him 10 lakhs. There is only 10 lakhs he is paying. They will give it. There won't be a problem. Within 10, because he's only paying 10 lakhs for 70 lakhs. This is the bank guarantee
Correct,
which
correct.
is given. So therefore, he can very well, and that too, it was a mistake of the HDFC. They will do it, and the order categorically says that once it is being given, or within the moment you give the bank guarantee to them, they will immediately within 3 days of 7 days return the amount to him. Get it?
Yes, ma'am, that will be.
That I'll take care of it. Oh, no.
So we'll do that only after getting your purchase
ask your
order.
client, ask him to ask his client for getting that. Giving the bank guarantee within 10 days. Make it ready now. Fresh bank.
After your lordship gives us the judgment. No?
My judgment is already given.
No, I mean, we get it.
No, you do that. Get it ready in the meantime. And
We'll
after,
get it ready, but.
and
we-
then you'll get it by Monday. On Monday, thereafter you get it done. Put the certified copy, and once you give it, within 3 days he will return it. They'll be bound to do it. They have no problem in returning it.
Yes, yes, ma'am.
Then the things will be okay. No? This is just patching it up.
Obliged, madam.
Deeply.
Yes, what is
Look, this is with regard to that transfer posting of husband and wife.
Hmm. Why?
Milord, I have
What
received
have you
the
done?
instructions, Milord. Already, Milord, the issue has been resolved. Milord, his request, Milord, husband has been sought to be transferred to the Changlang district. And we got one driver who wants to come to Itanagar, Papumpare from Changlang. So in that way, approval of the portfolio has also been taken, Milord. I am told that within 1 day or 2 days, Milord, the orders will be issued and they will be accommodated. Husband and wife both will be accommodated in Changlang, Milord.
Yes, who is there?
Yes, Lordship. Lordship.
Ah.
Yes. Yes,
Hey,
the petitioner number 1 has been transferred to
Ah.
Changlang.
You have
Then
been transferred?
I've got information, not I've received till now, but
So
I
therefore
got
nothing
information.
remains in the petition.
Yes, Lordship. This petition may be.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das, the learned counsel appears on behalf of the respondent number 1. Who appears for respondent number 2? So-and-so appears for respondent number 2. Give your names, counsel for the petitioner and counsel for the respondent number 2.
Dangan.
The petitioner,
You.
the petitioners in the instant proceeding are husband and wife. While the petitioner number 1, who is the husband, is working as a driver in the establishment of the Chief Judicial Magistrate cum Civil Judge Senior Division UPI in the district of Papunpare, Arunachal Pradesh, whereas the petitioner number 2 is working as a process server in the establishment of the Chief Judicial Magistrate cum Civil Judge Senior Division in the district of Changlang, Arunachal Pradesh. The grievance of the petitioners in both the in the instant petition is that the husband and the wife are staying apart, and therefore both have submitted representations. Mr. H.K. Das, the learned senior counsel, as well as the standing counsel of the Gauhati High Court, has placed before this court an instructions issued by the register of the Itanagar bench of the Gauhati High Court, which is kept on record and marked with the letter X. From the said instructions, it is apparent that the representations so submitted by the petitioner number 1 have been accepted And the petitioner number 1 would be transferred to the Changlang district, wherein the petitioner number 2 is discharging her service as process server in the establishment of the Chief Judicial Magistrate cum Civil Judge Senior Division. Taking into account the same, as the grievances of the petitioners have been duly taken care of by the respondent authorities, nothing further survives in the instant petition for which the writ petition stands closed.
High level.
My lord, that service matter, lordship fixed today, day before yesterday. Service matter, service tax,
Huh?
service tax matter, my lord. In respect of a restaurant, my lord. And restaurant, the name is, my lord, that mainland China. That it was in Gauhati, one was in Bombay, my lord. In this case, we have challenged the order passed in appeal by the commissioner, GST commissioner, my lord.
Is there mainland China in Gauhati now?
It was there in Gauhati, near my house, ABC, and one is the Mumbai. It was, my lord, and 2020 it was closed, and Bombay was closed in 2016.
You were a franchisee,
Franchise, yes, franchise.
then you are here.
Now it's no longer, it's finished. The business has been closed by this.
Mainland China is closed, but
Originally it's closed.
but
Franchise is. So for this,
Dona Food and Beverages is still there.
it is no, my lord, it's not there.
Are you saying that you are appearing for a non-existent party?
No, Dona is, that restaurant is not there. Lordship is right that, yes. The part is there, but the restaurant.
Now, what is your problem?
My problem is, my lord, whatever. Let me just tell the fact, whatever.
I'm not going to go into the facts.
Okay.
Here,
That order-
for the fact that you have come before this
No,
court on the
my
ground,
lord,
that you have not deposited that penalty, some
Yes.
amount,
yes, my lord.
and have also, there was a delay in filing the appeal.
My lord,
That's all.
that's all.
We
Before
condone,
that-
we condone the delay and you deposit to how
My
much
lord-
is the amount? 10%.
7.5%.
Then
My lord, just a minute.
Absolutely no.
My lordship is right. I'll never say no, lordship. Just hear me one moment, my lord.
no, I won't. hear.
Assessing authority has passed the
Sorry,
order.
I am not going to hear that because the order which is challenged out here is not an order to that effect. You have gone to the appeal.
Yes.
And in the appeal, thereupon this appeal has been dismissed on 2 grounds.
Yes.
One is non-deposit of alia, which you deposit within 7 days or 10 days. Second, as regards condonation, we condone the delay.
My lord.
Over.
Lordship, lordship has passed the order. Just, I want to, for my satisfaction, my lord, one issue, my lord. My lord, what is happening?
I also have the habit of upholding this type of orders. If I uphold these orders, then you are
No,
finished.
obviously, when lordship will pass the order, I have to accept and go. I'm just feel, my lord, the assessing authority, no notice was served to me, nothing was done. It is an unserved.
How do I know?
I'll short from this year. It
Show me
I
that no
annexed
notice was issued. to
page
you.
number 53, kindly see. 83.
Page
Page
number
83. Yes, page 83, kindly see, my lord.
83.
3, yes.
Yes.
First, they passed the order, 2022. I don't even know. 2024, I came to know they passed an order, my lord, impune order. Then I went to the office. When I went to the office, they gave me the notice, page 79, along with page 83. In the left side is
Page
undelivered.
80,
Page 83.
83.
83.
Ah,
This is a, my lord, from postal, this is a return, my lord, undelivered. On the top right side, just before annexure 10. It's not clearly marked, this one.
huh?
Annexure 10, lordship has seen annexure 10.
Yes.
Just been annexure 10, it is undelivered, delivered, it is written there. This document they have given me in the office in 2024. When I came to know, in 22 they passed an order. I went to the office.
You went and filed an appeal. You didn't come before the court.
In the appeal, my lord, have taken that ground, my lord.
No, very well. They urged that ground there. Why should we look into that?
And my lord, kindly see another thing. The entire amount we have deposited, my lord, the same notification was issued from Bombay also.
So what?
Bombay authorities have passed an order that no,
So
for
it in
Guwahati.
So it in Bombay.
Yes, my lord. Please just have a look at my lord page number. Bombay order, lordship may find in page number 61, my lord. It
No.
is page 61,
So show that
my lord.
before
Please.
the appellate authority. Not here. Heard Mr. M. Nath, the learned counsel, senior counsel, assisted by Mr. D.P. Bora, the learned counsel, appearing on behalf of the petitioner. Mr. S.C. Kayal, the learned counsel, who appears senior counsel, assisted by so-and-so, who appears on behalf of the respondent numbers 1 to 5.
Lordship, may
1 to 5.
Lordship.
The present writ petition has been filed by the petitioner. Challenging the
He's 92.
order dated 30/8/2024, passed by the respondent number 3, whereby the appeal so filed by the petitioner was dismissed, and further have assailed the show cause notice dated 21/10/2021 and the order dated 17/12/7/2022, passed by the respondent number 4. At the outset, it is very pertinent to take note of that the petitioner, being aggrieved by the order dated 12/7/2022, had approached the appellate authority, that is the Commissioner Appeals, challenging the said order dated 12/7/2022, as well as the issuance of the show cause notice dated so and so.
2110. 21. Page 79.
Pusto. Taking into account that the appellate authority. Footstep. In the backdrop of the above, let this court now take note of as to the reasons why the appellate authority had passed the impugned order dated 30/8/2024. The appellate authority had dismissed the appeal for 2 reasons. First, that the impugned order was passed on 12/7/2022, and the appeal could have been filed in terms with Section 85 within a period of 2 months, that is, on or before 12/9/2022. And the power which was there with the appellate authority to condone could not have been more than 1 month, that is 12/10/2022. However, as the appeal was filed on 4/6/2024, the appeal could not have been decided by the respondent number 3, who is the appellate authority. The second ground on which the appeal was dismissed was on the ground of non-deposit of not making the pre-deposit of 7.5% of the duty or the duty and penalty which are in dispute. Next. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. It is the specific submission of Mr. M. Nath, the learned senior counsel, appearing on behalf of the petitioner, that the petitioner was never issued a show cause notice. And it was only in the year 2024 when the petitioner had visited the office of the respondent number 4. The order dated 12/7/2022 was furnished along with the show cause notice and an envelope which is enclosed as Annexure 10 to the writ petition. It is under such circumstances the petitioner had approached the appellate authority by filing an appeal. The learned senior counsel further submitted that the issue involved in the proceedings pending before the issue, which is the subject matter of the impugned order dated 12/7/2022 passed by the respondent number 4, have already been dealt with by the who?
My Lord Commissioner, Joint Commissioner, Mumbai GST, page number 61 to 67.
By the Joint Commissioner, Mumbai GST,
Page 61 to 67.
as would be apparent from the order dated 25/8/2022. The learned senior counsel therefore submitted that this very aspect was not taken into consideration by the respondent number 4 in passing the impugned order dated 12/7/2022. And therefore, the petitioner be exempted from payment of the pre-deposit of 7.5% of the duty and penalty. I've also heard Mr. S.C. Kyle, the learned counsel, senior counsel, appearing on behalf of the respondents who submitted that the facts which have been mentioned by the petitioner are facts, the submissions so made by the learned counsel appearing on behalf of the petitioners relates to questions of facts which can be dealt with by the appellate authority. The learned senior counsel therefore submits that the respondent authorities would not insist on the question of limitation. However, the learned senior counsel submits that it is that section 35F of the Finance
Central Excise.
Central Excise Act
Yes.
1944 have been upheld by the Supreme Court in various decisions. And therefore, the question of exemption from payment of the pre-deposit cannot be permitted. This court has given an anxious consideration to the respective submissions and have also perused the materials on record. First, it is the opinion of this court that when an appellate remedy is available, it is the opinion of this court, taking into account the facts involved to the effect that the petitioner herein had no knowledge about the show cause notice, as well as regards had no knowledge about the impugned order dated 12/7/2022. which the petitioner came to learn only in the year
On
2024.
26/4/24.
Which
On
the petitioner
26
came to learn on 26/4/2024.
Yes, I received the copy on that, the in order, then went to the office and they gave me the shock notice and that envelope.
Come. The period of limitation ought to have been counted from the date of the knowledge of the petitioner. Inasmuch as the said order dated 12/7/2022 was passed ex parte. Considering the above, this court, in exercise of the powers under Article 2 to 6 of the Constitution, condones the delay in preferring the appeal before the respondent number 3.
Commissioner. Yes, Commissioner.
And the appeal so filed on 4/6/2024. You can't be knowing on 26/4.
This.
When did you come to learn? 26/4.
Yes, my lord.
Okay.
Then.
Okay.
Yes, I
And
stated.
the appeal so filed on 4/6/2024 by the petitioner before the respondent number 3 shall be construed as an appeal filed within the period of limitation. Next. Insofar as the pre-deposit of 7.5% of the duty or duty and penalty which are in dispute, it being the mandate of Section 35F of the Act of the Central Excise Act 1944, read with the Finance Act of 1994. The petitioner has to deposit the said amount for the purpose of consideration of the appeal on merits. The petitioner is given 30 days time to deposit the said amount from today. Next. In view of the above, the instant petitions therefore stands disposed of with the following observations and directions. The order dated 30/8/2024 passed by the respondent number 3, that is the Commissioner Appeals CGST, Central Excise and Customs Gauhati, is set aside and quashed. Number 2, the appeal filed before the Commissioner Appeals CGST, Central Excise and Customs Gauhati, that is the respondent number 3, bearing appeal number. What is the number?
Oh, no.
This is one number, na? GAP. What is it? Yellow at a map. Man number 508 5809, na?
Lordship.
Is that the number, appeal number?
No, Lordship.
Or the other one? Appeal Mool Adesh se.
Appeal number 305.
Huh?
305 GHYA.
This is the appeal number, na?
Lordship.
Okay. The appeal number so and so is restored to the file of the Commissioner Appeals, CGST, Central Excise and Customs, Gauhati. That is the respondent number 3. Number 3. The petitioner is granted
Provision in that.
30 days time for deposit of the pre-deposit in terms with Section 35F Roman 3, na? 35F Roman 3, Roman 2. 35F of the Central Excise Act 1944. Next. For a period of 30 days from today, the interim order passed in the instant proceedings shall continue.
Much of.
So further orders of stay shall be subsequent thereto. The question of stay of the impugned demand made on the basis of the order dated 12/7/2022 by the respondent number 4 shall be subject to such decisions of the Commissioner Appeals, that is the respondent number 3.
Much of.
Madam, yes, sir. What is this?
My lord, this was basically initially a challenge to the promotion being not effected to me and being given to the private respondent. Subsequently, during the pendency of the proceedings, I having retired and the matter having moved to the appellate court, my lord, the Honorable Appellate Court, Division Bench, my lord, said that you reconsider the DPC, whatever is to be done, and if something is there, you pay out the financial benefits. Thereafter, they took up the matter and rejected it. I am on the saying that my inter se merit was not better than the other person. Now, in a nutshell,
You are senior?
I'm senior.
Two?
Seniority cum merit was the yardstick, and in seniority cum merit, if I am senior with the minimal merit, that's what the apex court and the judgments have said, then the
Nowadays, they put 70% mark as the minimum merit.
yes, but in that case, the percentage of marks was not there. The ACRs would have to be taken into account, and therefore between me and him, if I am senior, doesn't matter if it's excellent, good, bad, average. If it is there,
You have to cross the minimum benchmark.
so there's no minimum benchmark indicated. That's my case. Number one.
No minimum benchmark?
But here the case is a little bit different. Basically, it is a case of seniority cum suitability. Although seniority cum merit is there, but
This is seniority
She
cum
earned-
suitability.
she earned, my lord, in all matters, my lord, seniority cum merit, suitability aspect always remains, my lord. She earned grading average. So how can we promote a person? My lord, penalty is a different factor. There has been, my lord, division bench has held that hold a review DPC. When we hold the review DPC, we found that in 1 year, she earned average grading. And because of that average grading, my lord, she could not be promoted. That is basically what the resolution says, my lord. And the petitioner has not built up her case that average grading which she earned, that was not that was, my lord, erroneously given, or that has to be expunged,
Or not,
In-
not communicated to her.
not communicated. The writ petition has not been, my lord, drawn up in that manner, my lord.
What I'm addressing this honorable court is that regardless of whatever the gradings are, regardless of whatever they are, in a test of seniority cum merit, then if I'm senior and I have the minimum merit, which you do not disagree or dislodge, you cannot deny promotion me on the count of better inter se merit. It is not merit cum seniority or merit with respect to suitability or suitability alone. It is seniority cum merit. In that context, I'll address. However, it will be unfair on my part if I do not apprise this honorable court that sometime in November 2024 is a judgment of this apex court, which my friend also knows, that post-retirement, there cannot be a reconsideration of promotion or financial benefits. That would stand in my way. Again, there is a judgment of the apex court on that point saying that if inter se some rights have been decided by a court, subsequent judgment would create a new law. But this would not be a good law, but it would hold crystallized from the parties concerned. In that view of the matter, my case being considered by the DPC would be good, and the change in the law by the apex court would not affect my case. But I have to address that point. It is against me, but I have to address. Some other day, if Lordship takes up the matter, my lord. It's a pending matter.
Apex court
2020
judgment will not come in the way. First, the apex court judgment, the recent apex court judgment, that will come later. First, the hurdle that has to be crossed is that, my lord, what about this average grading, my lord? That was never challenged nowhere, my lord. My lord, the procedure is that, my lord, if there is an average grading, my lord, you have to challenge that, you have to question first appeal, you have to submit application for expansion of the same. Then if you are aggrieved, you have to, and it is very specifically in the resolution, it has been said that she earned average. So seniority come merit or merit come seniority, suitability is the basic aspect of the matter. Whatever be the criteria, one has to be fit. So it's a case of unfit for promotion, my lord. Page 35 is the relevant portion of the resolution, my lord.
So your earlier round of litigation pertains to
Penalty.
a penalty
Penalty.
being taken into consideration, which should not have been
Should not
taken. And therefore say that, okay, have a fresh DPC along with this.
Gotcha. We say they applied the wrong yardstick.
Now, as on the date of the judgment of the division bench,
My lordships.
you're retired.
Yes.
2015 she
15 I
retired.
retired. 15.
2015 she retired.
Retired.
And when did
She
the
retired
DPC
on
happen?
31/5/2015.
The DPC?
Review
9/7/20.
DPC was held on 9/7/2020.
Where's the DPC?
Page
Page
31.
31, it's the type copy, my lord. And relevant portion, page 32. Para 7.
So we have to go into the question of admitting this also. I think I agree with Mr. Banik to that effect. We have to see as to the principle of seniority comes suitable.
Fitness.
No, no.
What is the criteria? Seniority comes
Seniority
next.
cum merit.
Seniority cum merit.
So,
Criteria is seniority cum
okay,
merit.
so if it is seniority come merit without the benchmark, how on the basis of average you have done?
No, average is relatable to her fitness for
Absolutely no question about this thing. But where have you fixed the benchmark?
No, that's a different. No,
That is the most important.
I understand.
I'm relying on a 7-bench judgment of the apex court.
What?
7-bench judge, I mean, judges.
That is for you to do before the
This
division
point
bench,
Come
not
to
here.
judgment later on, but the thing is that
Not the seven. We don't require 7 bench. It
That's
is
the point. On that
my
point.
single judge's bench will do.
Lord. For the Hadin part. Well,
Yeah, we'll
Yeah,
have
yeah,
it
yeah.
immediately after vacation. It's a whole matter. Person has retired. So list this matter on 16th of July 2026.
could it be on 14th below?
Absolutely no.
No,
16th is 16th.
Thursday.
Lordship.
If you do a high court matter, you have to be. Otherwise, leave high court matters to be other councils. There are many other councils who wants to do high court. Okay.
Lordship.
order cited.
Yes.
Yes, Lordship, this PIL is regarding the witness protection scheme which is provided by the Supreme Court in the case of Mahendra Chawla and others versus Union of India in the year 2018. Here, the Supreme Court has provided for establishment of vulnerable witness deposition centers. Through the RTI, I have come to find that the states have not complied with the directions of the Supreme Court.
Where is the Supreme Court judgment?
Next person. Also want to have. I only have one copy. I'm extremely sorry, Your Worship.
Where is it, madam? Which section? Where
Lordship,
do I
I
find it?
believe it is paragraph 36, if I'm not mistaken, of the judgment, where the entire directions have been issued and the witness protection scheme has been quoted therein, in the entire judgment itself.
Whether any state and parliamentary legislations have been made?
Lordships, the scheme itself is from, the scheme is quoted in the judgment itself. The
Understood,
witness
but,
protection scheme of 2018, it was framed by the government of India. And it was framed after taking into consultation 18 states, about 5 or 6 state legal service authorities and some other stakeholders. And thereafter, this scheme was framed in this particular matter. The Supreme Court adopted this scheme, and your lordships will find that in part 2 of the scheme, there are 7 or 8 parts to this scheme, your lordship. The first part is of definitions. Part 2 deals with the funds and the application and how, what may be the procedure to be followed. Now, part 2, clause 7L talks about the courtrooms, which is the grievance of the petitioner before your lordships. Part 2, clause 7L. Types of protection measures. L says usage of specially designed vulnerable witness courtrooms, which have special arrangements like live video links, one-way mirrors and screens, apart from separate passages for witnesses and accused, with option to modify the image of the face of the witness and to modify the audio feed of the witness voice so that he or she is not identifiable.
many of the courtrooms have,
Um,
as I could see in some district courts.
Yes, some courts have made, but mostly in temporary arrangement, Lordship. And
Which are the courts you have visited?
I've visited the Goalpara one.
The Goalpara newly it has been done.
Yeah, in
Have
Goalpara,
you
yes.
visited the new one?
Yeah, most of them are in temporary arrangement as have been
Now
stated by the government.
so-
Goalpara has constructed.
Temporary area, page number 306. Okay, I'll get.
Madam, have you given a submitted any report out here?
Yes, Your Lordships. I have filed 3 different affidavits. The first affidavit, Your Lordships will find from page number, it's, starts at perhaps page number 241, if I'm not mistaken. 239, Your Lordships. That is my first affidavit. The, for Your Lordship's convenience, there's a chart at page 306. Starting from page 306 is the chart that we have annexed, giving the status of all the different districts of Assam. Lordships have got it. 306. Baksa already established. Borpeta going on. Biswanath, nothing established as yet. Bongaigaon has already established, and so witnesses examined. Then next page, Your Lordships will find Kachar. Kachar, only a temporary structure has been constructed. So this is the difficulty. The reason why this this particular PIL has been sent to the infrastructure bench.
Now Silchar has a new court.
Lordship, this perhaps because this was filed in 2024, Your Lordships. Or
No.
no, I was 2025,
No,
21,
we
11,
do one
2025.
thing. We
Lordships,
do one thing, we pass an order
Lordships,
directing all the 4 states
Lordships.
to submit a report as regards the compliance in the respective districts in terms with sections clause 7L.
Lordships. In fact, I believe.
We need 7L as well as also another thing which is there. 7A and L
7A and L. Yes, Your Lordships.
as to the compliance in respect to 7A and L.
Lordships, everyone has filed their affidavits. Nagaland also, Arunachal, you filed their
No, I
affidavit.
think
But perhaps,
let us take a report
Lordships.
and then progress.
Yeah.
On as regards with as to how they are doing it as regards 7A and L. A says ensuring that the witness and accused do not come face to face during investigation and trial.
Yes.
Lordships, what has happened
So
is
that
if-
is for the purpose of the state to say.
Correct.
One, and as regards L is regards the structure. Users of specially designated vulnerable courtrooms which have special like live video, that is one. But the most important thing is we require that there should not be face to face while going inside the courtroom. There should
Therefore,
not
two
be-
doors, your
both
lordship.
of them should
Therefore,
not go together.
Lordships, correct. There was yesterday in the debate, the Honorable Chief Justice was saying the same thing, that having a temporary structure is not going to be enough. What we require is a specially designated courtroom which has two entries to it. So that is, and therefore, insofar as Assam is concerned, several of the districts have come up with permanent structures, but I'm not privy to whether they have those two court doors or not. And in some districts, it's only a temporary arrangement which has been made with one particular room. Wherever they could identify any space, they have designated it as a VWDC.
But I've
Um,
seen it in Golaghat, they have.
Maybe.
For-
But in
for
Kachar, your lordships, I
purpose
can
of
tell your
that,
lordships, in-
accused comes in some other states.
Okay.
And the witness or the victim out there comes to another.
Perhaps your lordship. Lordships, I can tell your lordships, in so far as Karbi Anglong is concerned, since I keep traveling to Diffu very often, what they do is that they have two different boards. On a day of a mediation day, they name it as the mediation room. On the day when they require this, they will name it as
Yeah,
the
it is a- the
WWDC.
reason is that
It's
we,
just
the Karbi Anglong court is
still under,
I think it is under the medical, they are using the facilities of the medical department.
lordships,
And
perhaps.
health, I think
No.
health or agriculture. So in fact, now some tender has come up
Has
for a
been-
new building. Once it comes out.
Comes up, it will perhaps be taken note of.
That
So-
will happen.
And Mizoram has notified the government offices as vulnerable witness deposition centers.
Huh?
They have not, the Mizoram government has notified the government offices as vulnerable witness deposition centers. That is not the direction of the Supreme Court. They are using such
Now, the
stopgap
fund
measures.
fund is given by whom?
Oh, by the state, your lordships. Although the scheme, no,
There are some
yeah.
finance from the central.
Central, yes, your lordship. I was just reading the scheme.
The union is, I think, doing it. Yeah, the funding is state witness
Part
protection.
two
That
talks
says
about
fund
fund
shall be
generation.
named as so and so, so and so. Fund the budget, so annual budget by the
State government.
So and so. There. Donation, contribution from philanthropists, charitable institution and individuals permitted by central government. Funds contributed by corporate responsibility. The state funds shall be operated by the Department Ministry of Home under the state/union UT government. Yes, this funding, how is the state, is the central government funding it?
Identify and who need.
I'm not aware of that, your lordships.
Yes, Mr. B. Gogoi. Who appears for the state of Assam?
Home Department perhaps is a party. But what query lordship has raised, that I will have to see instruction. Today I have been handed over the file. Yes.
We can also look into this
Yes.
aspect, like those NDPS courts.
Lordship.
I think there are some central government funding.
Why not?
First, they identify that these are the requirements, then give proposal, then they fund it. So we'll have to bring that.
Why not?
comprehensive
That,
thing. What actually is.
Detailed instruction I will place. Otherwise, the DGP has probably filed one affidavit, but probably these queries are not, cannot be meted out by.
No, so therefore we ask the, yeah, and ask
Lordship,
the-
if Lordship come to
is the
point number
central government
28,
party Here,
in
Central
point number
government-
28, it is mentioned here.
is the central government a party?
No.
Yes, yes. In point number 28, it is mentioned here that it is clear from the aforesaid events that the scheme is the outcome of the efforts put in by the central government with due assistance not only from the state governments as well as the union territories.
Where?
In point number 28, at the very end, Lordship.
Since the beneficial events so and so state and the union territories. All states and union territories also accepted that suitable can be passed by.
Doesn't-
state scheme and amendment of- in the enactment of- It's clear that the aforesaid event, the scheme is the outcome of the efforts put by central government with due assistance not only of the state and so on. Also under state, in a higher region not to accede to. I think we make the central government a party.
Central government is a party here?
No, Lordship.
We make the central government a party.
Ministry of Home Affairs.
Ministry of Home Affairs has to be made a party because it is under their aegis this scheme was made. And they are also, these directions passed by the Supreme Court, if the state is not in a position to make payment, the central government also, it says last 36.4, the central government should also support this endeavor of the state by helping them financially or otherwise.
Lordship.
This is the most pertinent line to be marked. Everywhere. State of Assam also has financial crunch? No.
That I will tell you.
Okay. Pass the order. Heard Mr. So-and-so, the petitioner in person. Mr.
The Home Department it made a party hearing. Probably man, it will be more effective. Only the DGPs have party hearing of all the 4 states.
So home will be required.
Yes, in all.
Okay. You also have a home, Nagaland? No. You have a home department or not? We make the respective home departments of all the home and political. What is your name? What is your department's name?
So what is the name of the, in Assam, it's Home and Political or something like that. It's Department of Home Affairs or Home. And Assam, it's a robot.
My Home and Political.
Home and political. Yeah. Home. Okay.
Respondent number 6 is the principal.
You are already there. All the principal secretaries are there.
Lordship,
In
Lordship.
that case,
All the state governments are there.
All these home departments are there. No, not necessary. Pursuant to the order passed by, pursuant to the order dated 16/6/2026, the present proceedings, which relates to overseeing the implementation of the directions passed by the Supreme Court in the case of Mahendra Chawla and others versus Union of India and others reported in 2019 14 SCC 615 have been placed before us. We have perused the materials and have taken note of some of the affidavits which have been filed, including the compilation of the data, which dates back to 31/10/2025. For the purpose of progressing with the instant proceedings, we have the opinion that there is a requirement of obtaining a fresh reports as regards the compliance to the directions so passed in the case of Mahendra Chawla and others, Supra, and more particularly to clause 7L, 7A and 7L of Part 2 of the Witness Protection Scheme 2018, which the Supreme Court had directed both the Union of India as well as states and union territories to enforce in letter and spirit till the enactment of suitable parliamentary and/or state legislation on the subject. First, we have also taken note of the directions which have been passed by the Supreme Court in the case of Mahendra Chawla Supra, wherein not only the responsibility has been entrusted upon the state governments, states oblique union territories, but also upon the central government to support financially as well as otherwise, so that the Witness Protection Scheme 2018 can be implemented in letter and spirit. We are also of the opinion that in order to do so, there is a requirement of making the arraign the Ministry of Home Affairs, Government of India, as a party to the instant proceedings. Accordingly, we implead the Secretary to the Government of India, Ministry of Home Affairs, New Delhi, as 11001 as the respondent number 11 to the instant proceedings. The petitioner in person is directed to file a fresh memo of parties before the registry of this court, and the registry, on the basis thereof, shall make necessary changes in the cause title as well as update the same in the CIS. Union. Where is Mr. R.K. Dev Chaudhary? He has left practice. Then? And you are appearing. Ms. So-and-so accepts notice. The learned CGC accepts notice on behalf of the newly impleaded respondent number 11. First, we post this matter again on 13th of August. 13th of August 2026. First, in the meantime, we direct the following. Number A. The state of Assam shall, in coordination with the legal remembrancer, shall submit a report before this court as regards the compliance to clause 7L of part 2 of the witness protection force, a witness protection scheme, so and so. And bring it on record by way of an affidavit. All of you also have LRs? A direction to protect that all LR could play. And Mizoram, you have an LR? Okay. All of us. We further direct the respondent number 11 to apprise this court as to whether any schemes have been floated for the purpose of enforcing and for the purpose of to apprise this court as to whether there is any scheme or any assistance provided to the state of Assam, Nagaland, Arunachal Pradesh, and Mizoram for the purpose of the Witness Protection Scheme 2018 to be implemented in letter and spirit. An update in that regard be placed before us on the next date.
Deeply obliged.
And Mr. Most important, Mr. B. Gogoi, we are putting you as appearing for those people, huh? For the state of Assam, all the state home and political, they are already parties out there. Another thing of much importance out here is what is happening. In each of the district states, this also goes for you also. We require the assistance of an officer from the engineering department. Engineering/architectural departments, so that these vulnerable witness centers can be duly brought in. I mean, how it is to be made in terms with taking into account 7L.
Yes.
Because 7L, otherwise you cannot do it unless neither by legally you or me cannot do it. It is, we require the assistance or expertise of engineering department and architectural department. So in that regard, how it can be done? We are just putting it this, so on the next state we will put it. Think about it. Huh? Copy of the PIL. A copy. Huh? The registry, taking into account the present is a public interest litigation, comma. We direct the registry to provide copies of the pleadings of the instant proceedings to Ms. So-and-so within 7 days.
Deeply obliged.
Yes, what had happened? Chief Judicial Magistrate. How much?
Almost completed, my lord. By end of this month, probably will the entire building will be more or less complete.
So then I think by June. What about the lawyers?
Lawyers part, my lord, they have proposed, they even, my lord, that going is there. But for one part in the, my lord, ground floor, there is the parking part. That they have proposed for, my lord, keeping as a bar, my lord. As well as one Assam type building, my lord, in the.
What about the on the side of it for the ladies? For the ladies on the side of it where there is some files or something to
Yes,
be
my lord.
Assam type house.
That part probably it cannot be located. But there's one more.
What is there? There's nobody stays out there. No, it is just uselessly kept out there.
Records, and there is no other place to keep the record. Now they propose, my lord, the BSNL building, my lord, that part it will have to be, my lord, brought in. Otherwise, my lord, difficult way to.
But the BSNL building is.
They say, my lord, approximately 30 lakhs, my lord, by that budget, my lord. It is there in the report, my lord.
They have talked with the but BSNL they have put it on top something.
No, first floor and
Nothing
second floor,
to
my
use.
lord.
Huh?
They will demolish one or two walls, my lord, so that they should be.
They have taken the concurrence of the BSNL.
So in the minor solar, yesterday it was held on 12/6. On 12/6, yes. On that day, when the meeting was held, it was registry. And accordingly, this decision was taken over.
Why don't you put those records there? In the BSNL?
Yes.
This is much better than to keep this. The ladies can very well use that room.
One can be put here.
and then you don't require 30 lakhs of rupees.
That part, my lord.
Then all the lawyers are accommodated in the same campus. And record is gone there, keep one sukidar there. No requirement of breaking wall and all records. It will be better than the present position.
Accommodation, lady bar member, existing 80 building at ZD. 30. Accommodation of vendors, so and so on this side, it's okay. So I think the ladies can be accommodated in that room. Think about that, that is one. And secondly, as regards the others, the other room, which is BSNL on the first floor, 1700 square feet. It is on the second floor. Or they are doing it on the ground floor.
One portion is in the
Building
first
is a G+2 story building, ground floor.
First and second.
Yeah, the approach of the building needs to be raised and finished by the block, paver block. That will only accommodate for
40, that's why.
40 is too less. What is the footfall?
But it was around, they say 2000 or something like that, but
1,000 lawyers don't come every day.
exactly, my lord. It will
Therefore,
be
the-
around 1000, my lord.
Therefore, the word used is footfall, not how many lawyers are there.
No, lawyers, so even even if I ask the footfall, they said it 2000, my lord.
They will
But
say
I
many
think
things.
minimum 800 to 1000 footfall will be there.
Is it? How many cases are there? Daily?
Every member,
Per court,
members are. Not at the.
my lord, as I previously asked, my lord, per court,
What is the
140
present seating capacity of the bar? Just give us that.
not, in fact, in my report,
What is the present seating capacity in that building?
they say
What is it? Don't come up with that. 1700 square feet means you are giving per person 40 square feet. What will be area, Mr. Gogoi, what would be that area for that particular room in the old building?
Where the record section.
No, not in our place, I mean, in our
That
old,
is
old
existing,
building.
existing 80 buildings.
Which
GAD
is,
building
one
in
is the
Bajaj
first is one room. Once you enter, on the left hand side, first is one room, then you have a bigger room where you have, and the next room, what is the area? It will be around 20 by 40.
40 years, 40 years is the length part when.
It's around 800 by 1,000. Yes. How many lawyers sit out there? Much more. Then why you are having 40 for that? Are you giving them each a table with a computer?
Tentative one month.
Huh?
Tentative.
1700 square feet. Tentative.
existing building. What's going to be prison?
No.
Boy. Yeah, that is.
What is the present?
Milord, in my report, Milord, I have indicated, Milord, there are per court 100 cases listed, and approximately footfall is 1000 to 1200, and now seat available is 2000.
In the present building?
No, it may be 200, 300 plus my, maybe, Milord. I haven't counted. Head count I did not do. But the thing is that it was my instruction given by the respective member of the bar. So on that,
That footfall part will be.
No, there are several rooms.
About the
First
footfall.
floor,
For
ground
the
floor.
time being, For a time being, forget about it. For a time being, forget about the football. See, we are with many constraints. Then also we are trying to have a resolution. What is the present sitting capacity in that building?
In that building.
That will give us a rough estimate. na?
With all due respect, my lord, that was the precise question I asked to the bar member. That was the precise question. And the answer was that they had 2,000, because ground floor also one
You
room.
have your own assessment.
True, my lord, there are two big halls in the ground floor, then first floor, then.
Is it hall like that 1,000 people are accommodated in that building? Never.
Be difficult to say, my lord, then it, I can.
Then this 2,000 will be 1,500 will be accommodated here. So
Will
they are
not be
counting
possible.
it 40 and 30.
But that count is also not correct. Well, 40, 40, 80 will not do any, will not serve any purpose. my lord.
That's why I'm saying.
No, they are doing it 1,700 for 40 persons. Therefore, I'm saying, are you giving 40 square feet to each person? 40 square feet,
That's true.
4 by
But
10.
Lordship had visited that place. Lordship had the occasion to see the place. my lord.
300 or 200?
What is the capacity in our bar? Sitting capacity. In the left, in the left side hall
400.
in front of the toilet block.
400.
Huh?
400, 500.
Then
The precise number, my lord, Lordship will give me some time. I can count the chairs and come up before your Lordship, my lord. One loud thinking, my lord. Just government will explode, subject to, my lord, what your Lordships considers, my lord. Will there be any place available in the presence of Cotton University? Something, if, because the university has got, my lord, big halls, my lord, old halls also there, my lord. Subject to what they say, my lord. That is
How is the Cotton University, which is, it is an autonomous.
my lord, if no is said, my lord, then
that's
to
why
it's
thinking is
difficult.
really low.
So no, it's only a 1,500.
I think, Mr. Gogoi, you need to explore it much on a more pragmatic level.
1,500.
1,700 for 40 is too less.
My lord, yes, 3,400 square feet more, 80%, my lord.
This is too less. 3,500 square feet is a pretty large area. So therefore, and the lawyers normally sit out there in the AR tables.
20
You may not have the luxury of what building you were having then, but then also that is an important aspect.
Look, in this building, existing building also, my lord, with all due respect, I have seen how they are sitting, my lord. It's like chair one by one, like school. So there is no luxury.
That is not there in our bar.
No,
Same.
there is no such thing, like, my lord. They are inconvenience
We are- we
already
are not-
there
We are
here
not-
also. my
We
lord.
are not saying that lawyers should not be, but we are constrained with space. We cannot
True,
create
true,
space.
true, so
Isn't
true.
it?
So true.
And if we go for a multi-story
My lord,
building,
one thing they have,
then only option left will be to demolish that sometime building and raise
one
a
small
building
suggestion.
there, which they has given an estimated around in crores.
No, true. One small suggestion, my lord, if possible. Ground floor of the GAD building, they have said that they have also given a drawing that 3,000.
2,800 square feet only. 80%.
3,000.
My lord, that calculation.
No, 3,000 square feet is there in the ground floor of the if we can do the thing in a phased manner, also that 3,000 square feet is there. We just will use the proper utilization of the each and every
At least
inch.
that space is available. We can
Exactly.
start with that.
We'll start with that. We'll use each and every inch of that 3,000
At
square
least
feet.
something will be there for the lawyers.
Exactly, my lord. And so far as that Assam type house is concerned, wherein the records are there, that can be
the second
cleared and
phase.
converted to a second alternative, because when your lordship visited, lordship also said that that can be earmarked for the women lawyers. Your lordship, when visited that place. So that can also be explored. Records, they can keep it somewhere else. That has to be also be explored.
Mr. Gogoi, this is the building, na, existing 80 building at GAD building campus.
Yes.
So this cost is also not very high, 12 lakh. It is possible that lady.
No, not that building. There is one, it's in a dilapidated condition, one Assam type building is there on the back of the.
So for
This portion.
for the time being,
At the end.
for the time being, you can go for these two at least.
Yes.
That parking and this Assam type. Then we'll think the possibilities go. You have your
records can be.
deliberation and then you can come back.
Records can be very well shifted because nothing there.
And any others here?
You are from Gauhati High Court.
Endorsement, they are going to construct one temporary construction in the.
Parking. That we
in the
understand.
open space.
In fact, on the left-hand side of the GAD building, lordships, when their lordships in long passage was there.
That is for vendors, I think.
Yes, lordship suggested that for vendors.
So
Lordship,
PLI code is behind that so that will be the passage for PLI code. So that won't be possible.
to CGM section. No, that is not the thing.
the ground.
Wait. It to CGM office. Okay.
PI
fine.
that's
side,
it.
yes. PLI section. PI section. Okay.
And the ramp part won't be possible. It is too steep. So they will have to use the lift.
So lift will be useful, Milo. Lift will be useful.
How big is the lift?
It's not that big.
8%.
8
So,
and 4.
8. Okay. That I have got a specific.
Fine, Milo.
So disabled
Eight will do.
person, then
With
if they
special-
also they can.
With first preference with for the developer.
Yes. 8 will do.
So we are done with this?
Regarding the Kaziranga guest house, already technical bid has been opened, 7 bid has been received this time. The evaluation is on, they say by 2 weeks or 3 weeks.
Hopefully immediately after rainy season.
Yes, it's possible.
And so far as courts funds have been given.
Hmm.
Now, what has happened out here with your paperless thing? How
Yes,
much
my
is
lord.
how much you have carried out?
A report to the
Digitalization?
some data we have received below.
Are we going to have it from reopening?
Also we'll have a look at the data, Milo.
It in very
A
patchy?
chart on the Duta copy. Lord. The numbers are not that encouraging me.
I think you should return the money to the state. It can
also-
use the money for some other purpose.
I also. It's not very encouraging number. If
Return the money.
Milo, this 259 is from the,
Just a minute.
I'm sorry. No, this 259 number is
So you
from the
return the
last
money.
date.
Return the money to the government.
Lord, I'll request the registrar to. Lord,
Then this
has
is a
to be
very
improved.
poor
Lord,
spirit.
this is
On
absolutely-
one hand, you are asking, you have not been doing the pending file.
My lord, my instruction is this.
And
since
what
it has
about the
started
now
it
e-filing
will
is being
take
done?
pace, my lord.
Huh?
It will take pace, my lord. Although this number is not very satisfactory, my lord, but it will take pace. That is my instruction, my lord. It will take pace. They will.
Those area table chairs. Huh? To tender. Huh?
Paperless court is done.
So, my lord,
So housekeeping, no
So
problem.
far as JM is concerned, my lord, a meeting has been held between the High Court of Registry and the Finance Department, my lord. A suitable solution has been chalked out. And very soon, I mean, they are going to take out a notification, my lord. The district judiciary will now be given enhanced limit, my lord. They have informally told me that it will be 20 lakhs.
Huh?
Which
How much?
20 lakhs.
Is it smaller than Guwahati High Court? The
No, no,
entire
one
district.
district.
One district.
Per district.
Each district.
Each district, my lord.
Put the word each.
Not the whole.
Not
Assam, my lord.
district judiciary.
Yes, my lord.
Now that means around 4 crores.
Yes, ma'am.
Each district judiciary will be given 20.
Yes, ma'am. On the estimation that the requirements, it will serve the purpose. Yes.
So can we record it? That's your submission that each district will now be, they are contemplating.
Let it be notified, my lord, because
Contemplating.
expected.
Contemplating.
It is expected. Yes.
Okay, both our word, your word will say proposed.
There is one more issue.
So guest houses, technical bids have been opened 7.
Yes.
Now, what is about the lying vacant creation? As regards the creation of infrastructure which are lying vacant out there. District of Bozali, there is a requirement of 2 port
Pending
rooms
proposals.
versus pending.
13 posts we could not fill up due to the lack of.
Mr. Gogoi, you are from the PWD. We are therefore saying it's high time. You see, at one point of time, it was going on like this, that we were entrusting everything to the PWD. PWD does it. Taking into account the infrastructure level of the High Court or the district judiciary is not such that, okay, 1%, 2% can very well deal with it. And it can be always outsourced to the PWD. Now what has happened, you see, the government has to come up with this, taking into account that the infrastructure level has gone very high. Some officer has to be also given out here somehow. Means specifically for the High Court. For High Court and the district judiciary, some officer has to be given who has also the expertise as regards designs. Because we see, whenever designs are placed, we have no idea. Designs now are being placed by what you call some architect somewhere of the contractor, and it is mooted out to us. We have no idea, head or tail. And at the end of the day, because of our ignorance, after the building comes up, then we find out, oh, this has happened. This two route, that vulnerable witness.
Building is completed. Now, you cannot do that now.
So the government has to think about it now. It's high time that the expertise of an engineer and an architect has to be somehow attached to the High Court somehow. It is absolutely, just for example, you have various superintendent engineers, executive engineer, whoever it is, you are attaching them to a particular thing. So similarly, like for the entire High Court, as well as the district judiciary, there should be one thing as regards the architect, as well as an engineer. So that the engineering aspect somebody looks into and the architectural designs is also being looked into. Because later on, with this so much of you must have seen that huge amounts of money is also being spent. Now, we as judges don't know anything much on the architecture. Whenever it is placed out there, somebody's on, we only say on experience. Just for example, if we take the example of Arunachal Pradesh. Arunachal Pradesh, the best part was this. The building was set up out there, first floor was being done, almost the pillars have been set out. Then one of the judges who had the experience of facing a problem in Mizoram, that the height of the building could not have been 10 feet or 11 feet. You see, normally what happens? A person gives an idea, just for example, this is the height of the building. If we have a 10 feet is okay, 10 or 11 feet is normal in all rooms. They also did it 10, 11 feet. But the fact remains that the judge sits on a podium, which is already 4 feet, and with 10 feet, then it becomes very short. So now here we have a 10 feet, if I stand up also. But from there it is 15. So these are things he did it on the basis of experience. But these are things which needs to be taken into account by these officials. Then only something will happen. Otherwise, we are saying now, because these are things which requires to be thought about, pondered, which I have said, like vulnerable witness. This design, a district judge, how it is moved. I'll give you an example how it is moved. This particular engineer concerned out there, the executive engineer comes over. He comes over and says that, okay, we need this particular thing. The district judge calls him. After the district judge calls him, then he gets hold of somebody. The engineer, he gets hold of some architect. And that particular architect makes a proposal. And this proposal is being meted out through somebody. And after that, it is being placed before the district level committee. District level committee approves it, the matter comes to the High Court. High Court also, judges, they don't know much how it is to be done. We don't have anybody. So under such circumstances, we say, okay, go away. And from our administrative approval, when it goes to you. Then you give the administrative approval, the financial sanction for which a tender happens. Then the problem happens. Just for example, again, the new High Court building. The proposal which was being submitted before us at that point of time, how it will be there. Now, with a new design which is being carried, now they are taking it up. Now they are thinking of it that the air ventilation which is there, you see the air will come from the north side. For the purpose of ventilation, you can't have the building in this manner. The ventilation has to be given in particular manner. These are things which needs to be looked into. Now, obviously, because of the High Court building, it's a very big project. The state is looking into through that. But how do we do it? You have seen it from
Yes,
your
sir.
personal experience.
Absolutely.
This is what is the
Absolutely.
problem which you are facing?
This what I request Lordship, if your Lordship puts it the observation in the order, and if the High Court moves the proposal, we can definitely
Because there has to be
take it forward,
somebody
Madam.
attached
Very
to
essential,
the High
Madam.
Court. Because then responsibility is there, somebody.
Well, a lot
That
of
he will
government
look
money will
into
be
it.
saved.
Like a person,
Lot of
he
government
can very well visit all the, he's, just for example, you have an executive engineer only for that particular area. But he will have the power to look into all the district judiciaries.
Maybe kind of a division, maybe kind of a division for judicial interest. A division
yes.
for judicial interest, led by an executive engineer or maybe.
It is possible, my lord. It is possible.
Superintendent engineer.
Yeah, whatsoever.
Yes,
This
yes.
will be a division for judicial. You are doing it. PWD, you have bifurcated for medical,
Yes, yes.
health and education. All education, building and health, they are bifurcated.
So why not for judicial
Judicial.
infrastructure? Because now it is coming up everywhere. So, and you see, if you did you ever preside out there in Tezpur?
No.
No.
I have not.
Now Tezpur, what has happened? It was a beautiful piece of land. We had a old building out there, very nicely, beautiful building, British style. Then one building comes up for the district judge. Once the building of the district judge comes up, it is made only from ground plus 2. Now it is the ground plus 4. Now if we take the option of that, they say, no, this is all corroded, you can only make 1. This goes there. Then in the meantime, what has happened? There are mushroom growth of 1 ground floor plus 1 in entire area. There's no space.
Whenever money comes that we need a construction for DLSA.
Space is
Where is
there,
the
so
space? Okay, construction. There is no sync between anybody.
that's true.
Now this is the big problem. Now what they are doing, you can't enlarge, make it bigger also because there's no pile foundation. Without a pile foundation, they are doing it on the basis of pillar foundation. With the pillar foundation, you can't go from G plus 3. So this is the big problem which is there, and there's no space now. At one point of time, if you remember, we have gone to Tezpur, in the middle portion, which I think still is kept intact, are those trees which are called the ajar trees. and till date, I'm told that the British,
Still they are monitoring.
they still monitor to that effect and to see whether in the month of April or May it is blue. So therefore, these are things which I think somebody can do.
This annexure C, my lord, lordship.
We're coming to that. Existing as per recommendation, the state level legal is pending with the government. Has been forwarded to revenue during the financial April, however, no response. District proposal is submission for process established. এটা নেক্সট এভেলেবল মোটামুটি কম চলিয়েছে চৰাইদেউ এই চৰাইদেউ 21 নম্বৰ ডিসি কমিশনার চৰাইদেউ হেৰিটো বাৰু applicable infrastructure for the remaining code is not available. Plans and estimates of new judicial building as well as residential quarter in pending with government PWD. Oh. Yes, Mr. Please raise the address.
Look, I'm told there is a meeting, my lord, so that's why he had.
What's about Soraidev? Yes, PMP, are you aware? What about this Soraidev building? Is it been approved in High Court? Huh? So it will now, it is to come to the. Then, so what are they doing till now? I could know for 2-3 queries they sought some modifications that has been sent long back, 2 years back. And see Bozali, Mr. Gogoi. First serial number 1, Annexure C. It was pending with the Revenue Department from 3/9/2024.
Revenue department, my lord, it's taking a lot of time. Even for the Hojai, my lord, Hojai also, my lord.
District has identified the
Yes,
land.
yes.
They have recommended.
No, my question is, why is it pending before the revenue department when, in respect to places like this, the district administration has been empowered? When we take up bench 5 matters, we see that these certain lands, the DC has been empowered.
Not all lands should go to revenue.
Huh?
Barring those VGR lands, these lands,
Huh?
those special lands where only state can do this.
The settlement has been, and you are not granting a settlement to an individual, you are granting a settlement to the government.
Institution.
Karbi Anglong is much better. We get this for a year. It's not done.
See, Gogol, I said, you are an additional advocate and forget about your finance status.
Yes, the register, Nagaland. What is it?
Your lordship,
Yes. What happened to creation of post? Okay. Now, Mr. Peter, what has happened as regards this, your technical, the computer, what? Computer technicians or what? What has happened? Some posts are to be created. We can't hear you. No, we can't hear you. What? One ICT from here and the other ICT from here. You have not been good. So under such circumstances, what is there? Why do you need jobs if you can't even connect this through video conferencing? We can't hear you. Anyways, we'll take it. Yes, Mr. Siti Zamir. We're sorry to keep you waiting.
No problem, Lord.
Yes.
It's our duty.
Yes, anything happening from your side?
Uh, With regard to the deputation of one electrician,
Ah,
it was proposed to be attached in the High Court. But then, as of now, as on 3rd June 2026, I have received a letter from the Chief Engineer, Engineer-in-Chief Power Department, that they are inviting the candidates who are willing to go to the High Court side. But as of now, there is no willing person. But what I would suggest, Lordships, instead of inviting applications, they should select some employee who can be deputed. That will take a prompt action. Otherwise, if they keep on opening like this, nobody will come forward. So they have.
Then the government, why are you not putting on deputation somebody out here?
Lordship, we have some arrangement. Otherwise, one post of NTS and one post of dock runner. It is already in the final stage, except that the one electrician. And even for that electrician, we have some arrangement. So if Lordship grants some more time, we'll complete the entire process.
Okay. And Mr. Peter, what is it as regards this?
Lordship, we have been waiting for the last 2 years. The matter is pending in the cabinet since March 2024, Lordship. And the status has remained the same in the last 2 years.
Regarding
Creation of 7 systems assistant, Lordship.
Yes, Mr. Imsong, kindly take instruction as to why it is still pending with the cabinet for the last so many years. You see there is a requirement of the 7 system assistants.
Yes.
Justification has been given, everything. Why it is still lying in the cabinet?
Yeah, Lordship, other than those MTS posts, even I myself, personally, I'm taking some steps so as to approve by the state cabinet.
You do one thing. We put it in our order. You get your instruction why it is pending as regards the 7 MTS, 7 system assistant.
Lordship,
Okay, on the next date.
Lordship.
We'll take it up.
Obliged.
A status as regards why the status as regards the proposal for creation of post of 7 system assistants. Okay.
Lordship.
Okay, then we can go ahead with Nagaland. We can dispense with you.
Lordships,
Yes.
few proposals have been sent during the pendency of this writ petition. So the Advocate General may be directed to come with those instructions. What is the status? So that
You, Mr.
post-creation.
Advocate General, you kindly obtain the complete instruction as regards those proposals which have been submitted, including why the 7 posts of AI is still pending in the cabinet.
Lordship.
Okay.
Thank you, Lord. Right.
The Lordship, on the last occasion, made an observation regarding the NDPS courts. So there was a meeting on the 12th of June between the registry and the judicial department, and the NCB was also there. And it was decided, pursuant to the decisions of the meeting, my lord, the registry has submitted proposal for setting up 2 additional NDPS courts in Sribhumi and Kachar. So we have received additionally. Beyond the 7. 7 plus 2, 9. And also it was observed that NCB will take it up with the Home Ministry for setting up 1 additional court in Kamrup Metro.
Union
And
Miss Union. I think.
Kamrup Metro and Hojai, my lord. So we'll have 11 in that case.
Fine, NCB will give proposal, it will come.
Yes,
But what
we
you
will move
said
this.
about the 7,
And
which is
now-
already accepted.
No. Now, my lord, 7 plus 2 will take it.
Go for maybe for case wise.
Yes, my lord.
But don't think that this 7 is there, again 2 will come, then again 1 will come, so we'll send it.
No, no, my lord. Now we'll move before the authority.
Ah.
Completed for approval.
No, that 7 should not wait for 2, my lord.
7 should not wait.
No, no,
for
two
Seven
has
should
already,
not-
two have already
No,
come,
no.
so we'll move together.
Okay.
Madam, you also take instructions, one thing. Why in the other states of Mizoram, where you have a lot of NDPS, Nagaland, huge, as well as Arunachal, huge. Mizoram, no. Why there is nothing mentioned about them, those states, NDPS courts? Because I don't think they have it in Nagaland.
No.
They don't have it. Now, what is happening in Nagaland that is interesting? The district judge is also the special NDPS, special judge NDPS. The district judge is also the MSc. The district judge is also the POSCO. The district judge is also the family court. What else do you require?
In fact,
5 in 1.
This, what, UPR.
UPR.
UPR is also same, isn't it? Arunachal Pradesh.
Same.
How is
Isn't
it possible?
Chandran? Same.
Same scenario.
No, there has to be, and more particularly in these 3 states. Assam is there, you are getting 9, it's good. But in these 3 states, you see, in Assam, you are getting half of it from that route from Nagaland.
Yes.
Yes.
One is Nagaland and the other is from Arunachal. So how do you take it?
And
The union is not going to think about the state of
the accused
Arunachal.
from Nagaland and these states, my lord, once they get on bail, we don't get hold of them. The courts there is very essential.
And it is very difficult for that particular judge.
Judge to handle. And beyond that, normal criminal appeals. Other cases, customary appeals.
Nowadays, with this, the earlier the jurisdiction was with the DC. Now all jurisdiction of the DC has now become to the district judge. I'll tell you the example of Kohima. Kohima, they have one district judge who functions the entire all these things, and you have a CGM who functions not only the duty of a CGM, the civil judge, as well as also judicial magistrate first class. Because you don't have a grade 3 now, till now. So in our court, you have 2 judges, the entire district of Kohima. So therefore, we put it in our order. You get your instructions as to what are you thinking about NDPS courts,
In this
because this is as per a Supreme Court judgment.
Yes.
Yes, my lord.
So, Mr. Das, kindly provide the reference of that judgment.
Minutes. Yes.
Yes, as regards that, what are you
fact, it
thinking
was
about these 3
Central
states,
government.
NDPS courts? Special means you cannot be assigning the role of a special judge. It has to be different. Okay, we can do done. We'll pass the order, we'll fix it.
And Gogoi, about this Soradio, what is happening? I think it's
We'll take instructions, my lord. Yes.
Not revenue and this Soradio. Rest are small work, boundary wall and all they have closed.
We'll take instructions.
Because for Soradio, there was a proposal that the existing building will be demolished and the entire court premises will be shifted to the deputy commissioner's office because they are having a new deputy commissioner.
Okay.
In between somebody will be allotted, then again it will be a difficulty for Soradio.
Although as of now in Soraido, 2 courts are still functioning in the within the campus of the deputy commissioner. So there is a requirement. Anyways, we have it. Sometime we'll fix a date and give it to you after vacations.
My lord.
I think we should start sitting, take up this bench from next time onwards at 2 p.m.
my lord.